Before the board begins its deliberations on the Pine Oaks Village 4 comprehensive permit application, I want to offer a brief procedural reminder for everyone. As required by statute, the public hearing portion of this application has been formally closed. This means that while today's session is an open meeting, it is not an open hearing. The board may now discuss the application amongst ourselves, our consultants that are here, referencing the testimony, documents, and materials that were submitted before the close of the hearing. Because the hearing has ended, we are not permitted to take any additional input, verbal or written, from the applicant, their consultants, abutters, or members of the public. Our role at this stage is to evaluate the record as it stands and deliberate solely on the evidence already entered. We appreciate the high level of engagement throughout the thoughtful feedback and the time the community and the applicants dedicated throughout the hearing process. That input has shaped the record we will now rely upon. With that clarification, the board will proceed to its deliberations. Hi, I'm Brian Sullivan, and I'm the chair of the Harwich Board of Appeals. Welcome to the meeting of the Harwich Board of Appeals on this date, December 1st, 2025. The purpose of this meeting is to deliberate case number 2025-21, comprehensive permit application by Queen Anne Acres LLC and Mid-Cape Church Homes, Inc., DBA Pine Oaks Village Homes. As required by law, the town may audio or video record this meeting. Any person intending to either audio or video record this open session is required to inform the chair. I would like our board members and consultants and secretary assistant the board to identify themselves.
David Nunaway.
Chris Murphy. Alexander Donahue.
Brian Sullivan.
Kenneth Dixon.
John August.
Christine Flynn, Town Planner.
Amy Questle, Town Council. Rachel Lohr, Zoning Compliance Officer.
Okay. Well, thank you. Folks, regarding going forward, and I think, actually, also, I need to have Marilyn, are you online? Can you identify yourself, please?
Yes, can you hear me?
Yes.
I'm here.
I need to state your name, please.
Marilyn Rotz.
Okay. Marilyn's an alternate member who's today off-site and is online with us. Okay. All right. As far as proceedings, of course, we have the draft decision. Everyone has that. Also in front of you this morning which I presented, is a memorandum regarding the decision on. Okay, we all set on that? All right, thank you. As a matter of fact, it reminds me to silence my phone before that happens. So thank you very much. So I won't be embarrassed myself. Okay. If we could all silence our phones. Okay. There's a review of the draft document by Town Council. And also, on materials in front of you are, we have, there's a review of the waiver requests that were done by the applicant. And I think today, as far as going over things, the first set of proceedings should be on reviewing the waivers. Everybody in agreement? Okay. All right, let's do that. I did. The case was read in right at the beginning. But thanks for reminding me. No, I wrote that in. Amy, I'm assuming we should take each one waiver at a time, correct? Okay.
You don't have to vote on them one waiver at a time. You can do what is called a consent calendar, where you go through all, kind of like what you do at town meeting with the budget. You run through all the lines, and then if anybody has a question on it, you can have a hold. You can vote on them all at once and then do the holds after, or you can vote on them one by one.
Okay. I think probably, I would say obviously by, we can probably look at the whole thing, and then,
Same time.
okay. Anybody else have any other opinions on that, in the review? Or perhaps we look at it by section based upon, well, we'll take a look at it, okay? All right, so we're looking at the waiver request from Pine Oaks Village. It was updated October 7th, 2025. The first article was Article 4, Interpretation and Application. Way to allow buildings and uses not otherwise allowed in the zoning bylaw.
Mr. Chairman, what about Chapter 255, lawn construction and excavation?
Excuse me, I'm sorry, I was looking at that, that was a heading. Thank you very much.
Excuse me, Amy? Can you put a microphone in front
Oh, thanks.
of you?
Okay. All right, so Chapter 255, Obstructions and Excavations. We waiver requirement to apply to the Director of Highway and Maintenance for excavation license. Okay. Now, I don't recall discussing that at the October 14th meeting. What does that involve regarding the difference between doing the waiver on that versus requiring them to get an application?
Because this is a comprehensive permit, all of the, any permit that's required locally is issued by this board.
That I understand.
So he's asked, it's a waiver
Okay.
to not have to apply, which
All
is standard.
Okay, thank you. Okay, anybody have any questions on that?
No.
No.
Next is the application 325-7, waive to allow buildings and uses not otherwise allowed in the zoning bylaw. 325-8, waive to allow multifamily residential uses in buildings. 325-9, waive to allow multifamily residential uses in buildings. I'm still on Article 5. 325-12, road construction requirements for a certificate of occupancy, waive to allow roadways as shown on plans. Table of uses and regulations.
Brian, on that one, do we
Oh.
need to reference which plan versions?
That's in the decision.
Oh, that
In the
would be-
decision, there's going to be a reference to the approved plan.
Because I know there's been revisions since the
Yeah.
first.
Okay. Table of use regulations, waive to allow multifamily residential uses in buildings. That's Article 5. Anybody have any questions on Article 5?
No.
No.
Okay.
Well, the first one you read was Article 4.
And 5.
You read this
Right.
one?
Yeah, I read Article 4 and 5.
Yes.
Thank you. Any questions on Article 4 as well? Thank you.
Yep, he read this one also. So we can vote on that.
Perhaps we, now, as far as on the assigned voters,
Should we do assign voters until we vote on the entirety?
yeah, that's a great question. In case we don't finish deliberations today and we have a different set of voters on another day,
You
Would-
vote, only the regular members vote unless somebody is absent.
right, so if one of the regular members is voting, is absent, and we have to do deliberations on a second day, are we waiting to do one vote on when everyone's together on that final thing, or can we, if 5 members are here today and they vote to approve a waiver, and then we don't complete the decision and the deliberations until another day, and that one of those people is out, now what happens?
We're going to do one vote on the whole entire decision, which includes the waivers.
So we wait till the end. Okay. All right. Okay, no questions on 4 and 5. Article 6. The applicability of area height and bulk regulations. Waive to allow buildings as shown on plans as described below. 325-16, tables of area and height and bulk regulations. Waive to allow buildings as shown on plans and as described below. 325-18, additional regulations. The applicant requests a waiver from the minimum lot width along the front yard setback line and the maximum shape number of 22. The provided shape numbers are depicted in the table below, which everyone has that table, correct?
Yes.
Okay.
Yep.
325-20
No, you gotta finish this.
on B. Okay, well, B, the applicants request a waiver to allow more than one dwelling unit per lot. Thank you, Ken. Storage for human use or occupation, 325-20, waive to allow buildings for human use or occupancy greater than 2 stories as shown on plans. 325-21, Table 2 area regulations. The applicant requests a waiver from the front, side, and rear minimum required property line setbacks. The applicant proposes the minimum front, side, and rear setbacks as shown in the table below, which we've all reviewed. Okay. 325-22 and 325-23, Table 3 height and bulk regulations. The applicant requests a waiver from the height requirements as shown below. Okay, any questions on those articles?
No.
No.
Okay.
No.
Article 9, off-street parking and loading requirements. 325-39, off-street parking schedule. Applicant requests a waiver requiring 2 off-street parking spaces per unit. The applicant proposes 1.5 off-street and on-street parking spaces per unit, large building, and 2 off-street and on-street parking spaces per unit for the townhouses. 325-42, design requirements. The applicant requests a waiver of the parking space dimensions under 325-42K for 90-degree parking and parallel parking as depicted in the following table. Everyone has the table in front of them. The applicant requests a waiver of the parking setback requirements under 325-42L as depicted in the following table. Further, the applicant requests a waiver from the prohibition of allowing a parking lot of greater than 4 spaces from being within the front yard setback. And we have the table in front of us, folks. 325-43, landscape requirements. The applicant requests a waiver of section 325-43C of the 10% interior landscape islands requirements for parking lots containing 20 or more spaces. Parking lots associated with large buildings 1, 4, and 5 have been less than 10% interior landscape areas as follows. Large building 1, 5.7, large building 4, 2.4, large building 5, 7.6, all percentages. Any questions on these articles? Okay.
No.
Again, this is everything we went over during our October meetings. Article 10, administration and enforcement. 325-55, site plan approval. Waive the requirement to apply to the planning board for site plan approval and requirements of this section. Okay, we're done with this particular chapter. Chapter 325 on zoning. I'm assuming no questions or comments?
No.
Okay. On to Chapter 400 for subdivision and land and site plan special permit regulations, which was adopted in November 12, 2008. Waive any requirements to apply to the planning board for a subdivision approval and for compliance with requirements of this chapter. Without limiting the generality of the foregoing, the applicant specifically requests the following. Section 400-7.1, project review fees. Waive any fees for third-party review by the planning board for the review of the preliminary plan. It is assumed that any third-party review of the project will be engaged by the Board of Appeal and will cover review of the preliminary subdivision plan, which of course were all of our peer reviews that we had hired. Section 400-10.
If I may, that also includes future peer reviews.
Okay, including future peer reviews. Okay, thank you. Section 400-10, subdivision filing. Waive the section in its entirety as the preliminary subdivision plan is required to be submitted to the Board of Appeals with the 40B application. Section 400-11, subdivision review procedures. Waive the section in its entirety as the preliminary subdivision plan will be reviewed as part of the comprehensive permit review process. Section 400-12, design standards for new roadways. Waive subsections A2, A5, B, and C in their entirety as the design intent to meet subsections A1, A3, A4, D, and E to provide a safe yet speed-restricted design that minimizes clearing and grading, provides effective drainage and stormwater management, and offers an attractive road layout, which is shown in Table 1, referenced in this section 400-12A. 2 provides recommended geometric design standards for collector roadways servicing 100 or more units. The table below provides recommended dimensions criteria and provided dimensions criteria where they differ. And you all see those tables below us? Okay. Any questions?
No.
Okay.
One question. There was the stormwater frequency, was it 50 years or 100? What was the one we agreed that?
We finally, it's part of the conditions, but they agreed to a 50-year stormwater management system.
Okay.
Okay. Originally, they were looking for 25, but they agreed to a 50-year stormwater management system.
That's in the condition.
Correct.
All right. So we grant the waiver and then add a condition?
There's no waiver.
There's actually, excuse me, that one is crossed out on your table.
That one is crossed out, okay.
Yeah.
I want to make sure. Thank
Yep,
you.
that's crossed out, so we're not waivering that at this point. That's crossed out. What the table shows is minimum road width going from 22 feet to 20 feet, and minimum radius at street center line, 400 feet going to 50, which has been approved by the fire department and the police department. Further, the applicant requests waivers from recommended street design standards displayed in figures 3, 5, and 6, and 10 for the roadway width and utility locations, figure 3, use of leaching basins, figure 5, spacing for catch basins, figure 6, and accessible parking space dimensions and parking lot setbacks, figure 10. Any questions on that section?
No.
No.
Okay. Section 400-13, design standards for utilities. Waive subsections A4 and A5 in their entirety as the drainage and stormwater management design is designed to convey the 50-year storm and managed runoff. Provide catch basins where necessary to maintain safe travel lane width and treat and infiltrate runoff within underground chamber systems and surface depressions are not in leaching basins. Section 400-14. Required improvements and specifications for construction. Waive A1, C2, E2, L2 in their entirety as figures 3 and 5 are not applicable to the proposed roadway typical section and drainage design. Hooded, deep sump catch basins are provided. Roadway clearing and grubbing will be based on the proposed typical section and may be less than 35 feet in some areas. The drainage system has been designed to safely convey and manage stormwater runoff without the use of leaching basins. That is the end of chapter 400. Any questions, comments?
No.
No.
Okay. Chapter 310, Wetlands Protection. Waive any requirements to apply to the Conservation Commission for approval under this chapter and for the compliance with the requirements of this chapter, without limiting the generality of the foregoing. The applicant specifically requests the following. Section 310-3, Jurisdiction. Waive subsection A in its entirety. This chapter does not contain substantive provisions. It only contains procedural provisions for applying to the Conservation Commission. The substantive provisions are contained in Chapter 295 of the Harwich Town Code, Comprehensive Stormwater and the Illicit Discharge Restrict Regulations, and in the Town of Harwich Conservation Commission Wetlands Protection Regulations addressed below. Comprehensive Stormwater and Illicit Discharge Regulations enacted per GL C-83, Section 10, in Chapter 295 of the Code of the Town of Harwich. It's quite exciting reading, isn't it, folks? All right. The project is exempt from these local regulations because the project will be reviewed under the jurisdiction of the State Wetlands Protection Act, and therefore no waiver is required, provided, however, to the extent that may be deemed applicable and without waiving the generality of the foregoing, waivers are requested. From the local bylaw, as listed below, waivers are not requested for state and federal requirements under the Wetlands Protection Act and the National Pollution Discharge Elimination System, or NPDES. The requirement to prepare and submit an NPDES Notice of Intent, NOI, and SWPPP with a stormwater permit application is not applicable. I actually believe we addressed this later on in the decision on doing review of conditions as well. Okay. The requirement to prepare and submit an NPDES Notice of Intent. Oh, sorry, I just read that. Apologize. Section 7. The stormwater management plan and calculation submission requirements are not applicable. Section 9. Erosion and sediment control plan submission requirements. Section C, waiver for the requirement to submit a SWPPP with the erosion and sediment control plan. Section 2, D3B, waiver for the requirements that the erosion and sediment control plan contain trees with a caliber 12 inches or larger, noting specimen trees in forest communities. Section 14, performance bond. Waiver the requirement to submit a surety or cash bond or other means of surety acceptable to the town prior to the issuance of any building permit for the construction of a development requiring a stormwater management facility. Okay. I have a question on Section 14, the performance bond. Does anybody have any other questions or comments? Okay. Amy, can you address the performance bond again? At one point, I thought we could waive it because any lack of performance would be taken care of by the fact that the town would not issue a certificate of occupancy, which would control that, seeing that in this construction, everything's going to be rented out. So it's not like we need to protect a homeowner that had bought a land site in the development or bought a condominium. So that's why I didn't feel the fact we needed to have a performance bond.
So this, under section 14, the performance bond is required prior to the issuance of any building permit. So, yes, you could substitute you can substitute the performance bond for for the reliance on a certificate of occupancy. The problem there is that the certificate of occupancy is issued pursuant to the building code, which is the state building code. So you technically have no authority to issue a condition that restricts the issuance of an occupancy permit. Because under the state building code, if they are in compliance, then the building commissioner has to issue the occupancy permit. So locally, you can't regulate the occupancy permit.
But if they're in compliance, that means they built the whatever correctly, particularly the sewage treatment plant, and so that a bond...
So this has nothing to do with the sewage.
Well, I realize that. I'm just thinking
treatment.
overall.
This is only stormwater.
Stormwater, thank you. So basically, you're recommending that we don't waive the bond?
Correct.
Okay. All right. And what, on a performance bond, who determines the amount of the bond?
The applicant and peer reviewer.
And which peer reviewer is doing that?
The town's peer reviewer.
Okay, so that'd be VBH? VHB?
VHB, yes.
Okay,
The civil peer reviewer.
they determine that. Okay.
The applicant submits a scope of work and cost of work, et cetera, and then our peer reviewer confirms it.
Okay. So we basically have to note so far, this is, well, we can go over this, but this is one waiver which obviously we can't consider.
Yep, we'll handle this at the end.
We will, okay. So even if we approve or mention the waivers, you're going to, as far as how are we handling that at the end in relationship to everything else that we might be approving? That's all I'm asking. We're not going to vote and approve all the waivers. We have to approve it with the exception of whatever.
Correct.
Okay. Town of Harwich Conservation Commission Wetland Protection Regulations. Again, as we go through all these waivers, I believe there are some here that we've been looking at that are also being handled under conditions that we're establishing in the decision. Waiving requirement to apply to the Conservation Commission for approval under this chapter and for the compliance with the requirements of these regulations, without limiting the generality of the foregoing. The applicant specifically requests the following. 1.104, Resource Protection Areas, Section 2, Buffer Zone. Waiver for area where land disturbance is proposed within the barrier zone as shown on the plans to remove the requirement that all such trees must be clearly tagged for the Commission's review. The Commission reserves the right to designate certain tagged trees for preservation. The removal of trees of 4 inches diameter at breast height, DBH, shall be evenly distributed to protect the canopy and overall environmental interest. Waiver for area where land disturbance is proposed within the buffer zone as shown on the plans that prohibits new turf or sod lawns. Waiver for area where land disturbance is proposed within the buffer zone as shown on the plans to remove the statement, other kinds of proposed activities in the zone will be closely scrutinized and regulated with very few activities permitted. Waiver for area where land disturbance is proposed within the buffer zone as shown on the plans to remove the 2.1 mitigation requirement. (106) Lawns. Waiver for area where land disturbance is proposed within the buffer zone as shown on the plans to remove the prohibition of no new turf lawns shall be permitted in the 100-foot buffer zone on an undeveloped lot. 6, waiver the area where land no, 6 is,
6 is struck.
6, they,
That was renumbered as 6.
so it was renumbered.
Okay, that's got it.
Okay, thank you. Waiver for area where land disturbance is proposed within the buffer zone as shown on the plans to remove the prohibition of mow lawn to height under 2.5 inches to promote a deeper root system to absorb nitrogen.
Greater than,
Isn't that more than,
yeah, greater than.
so that would be greater than?
Oh, excuse me, I'm sorry, did I say less than?
You did. Yes.
I apologize. And since my wife cuts our lawn to about close to 4 inches, so we got some pretty thick sods, so. All right, so greater than, equal to, or greater than 2.5 inches. Thank you. Erosion control. 7, waiver for area where land disturbance is proposed within the buffer zone as shown on the plans to remove the requirement that any activity that denudes or bars 50 square feet or more of ground to remove the ground within 100 feet of the resource areas requires revegetation with indigenous species as specified by the commission or stabilization with bark mulch, core matting, or other appropriate materials throughout the second growing season. Any questions on any of that?
No.
Okay. Town of Harwich Board of Health Regulations, design, operation, and maintenance of small wastewater treatment facilities.
Chairman,
Yes,
can I ask a question?
absolutely.
Amy, I believe that you told us this section was not applicable because it's not going to fall under the small wastewater treatment guidelines?
It's not going to, it's he has right here, the wastewater treatment plant will be permitted through the Mass DEP groundwater discharge permit regulations. So again, I'm actually looking to see, was there any time in the future that this got taken off? It actually looks like this was added compared to the chart that they had given us. But I do not think that this applies.
What's your recommendation? Do we go through this now?
That's up to you. We don't want to grant a waiver that's not necessary, because that would change things in the future. That could change things in the future. They're not proposing. Yeah, I don't know why they have it on in here.
If for some reason we make a decision and we don't include this, they obviously can go back and request
Correct.
an amendment.
So.
So let's leave it up.
Yeah, they do have, yeah, it's on their most recent version, but no, I don't think we need this.
So that would take us from,
Their attorney agreed with me too at the hearing
okay.
when I expressed that opinion. Maybe not.
So that takes us this, so I don't read 1.3, 2.2, 3.8, 510,
Basically,
and there must be another page here someplace. There's always an extra page.
20.
and eliminate 520, 600, all the way down, 611, 612, 620, 710, and 730, is that correct?
Yeah, as you can see on all of these, Mr. Chairman, it says that it will meet Mass DEP groundwater discharge permit
Okay.
requirements.
All right. Okay, well, actually, I believe that completes the waivers. All right, so we will address any vote on waivers with the full decision, correct?
Correct, except the section 4 of the stormwater. Section 14, I'm sorry.
Performance bond.
Yes, okay. Okay. Alrighty, next up, I believe, is to start the review of the draft decision. You all in agreement? Yeah. Okay. All right. So, as we go through this, let's clear off some of my desk here. Everyone has this, you have two documents, a very comprehensive draft decision that was prepared by town council. And then also, there's a memorandum dated today, which is a review that was done between myself and Ken. Sat down just to get a review done ahead of time and organize what we thought were suggested comments, questions, and suggested changes and additional inclusions, for the draft decision, try to move things along. So it, I think basically, you need to start to proceed to take this one page at a time, correct, Amy?
Sure.
Or do we have to read it into the,
You don't have to read it out loud. I'm not sure how, provided the board all has a copy of it, right?
We do.
yeah, all right, all board members, you have a copy
Yes.
of the decision, okay?
Are you just going to jump back and forth between the two documents, though?
Well, I thought I'd be taking each page, and obviously, my document that I did is in the same order as your decision, except for my initial questions.
Right, that's what I'm asking about.
Okay, so I have my initial questions, and then we start with your background. So, kick things off here. Throughout this document, there are several references regarding the board's designee and peer consultants. So before we get into the decision, I just want to get some of these things answered so I understand it better going through. Who designates, the board designee? Because there's various aspects of this proposal, whether it's site plan review, the sewage treatment plant, whatever, conservation aspects that would require, different expertise. So the question is, who's going to be the board's designee? What's your recommendation, and how does the board assign a designee to review this project?
The board's designee would be your peer review consultant, would be VHB, and they would handle everything.
So that's going to be our only board designee.
I mean, I guess unless there,
because you also have like TRC,
Peer reviews for traffic, are there in the decision? We'd have to look. Yeah. Yeah, so I don't know, why would we reduce anybody else?
well,
Wouldn't,
you know, so we're not, like, we had TRC as a consultant, correct? And they were doing the
Environment.
environmental issues.
VHB can handle that.
Okay. All right, so anytime we see designee, we're thinking it's VHB.
Yes, it would be VHB. It would also be somebody that, you know, staff could recommend. If it comes up in 5 years, there has to be a peer review, you know, as long as, you know, staff could recommend somebody else if VHB is not available. It's just someone that is paid by the applicant that works for you, for the town.
No,
But
your
you-
question more-
The board is generally out once the decision is issued. We cannot have conditions that bring decisions back to the board.
correct.
So by saying the board's designee, we're leaving it open to, we're not pigeonholing ourselves into a certain person or peer reviewer. A lot of times we'll say that the peer reviewer shall be XYZ unless determined differently by staff, something like that.
So as far as on staff and making a determination, is that going to be the planning director?
Yep.
Building commissioner?
Could be both
Okay.
together.
Because of some aspects of this, when it gets into areas of construction, I would think the designee would be the building commissioner versus VHB.
Yep, it could be. Yep, but the building commissioner would not be would not necessarily be your designee. The building commissioner is the person that enforces the entire decision.
Okay.
So in any means, they're the person. So this decision will be enforced by the building commissioner.
All right.
Is your question more procedural, that we would have to take a vote to designate somebody, or?
No, I just kind of,
You have to, because it'll
No.
be a condition.
it isn't, I just was kind of, because throughout the document, assigning various aspects of the, you know, different timelines of construction, development, there's review process. And it talks about using the board's designee to do that review. And it varies between conservation, construction, you know, environmental, whatever. So I was kind of thinking like, okay, at what point and who is going to be a designee and who assigns them? That's what I wanted to know. Okay. So going forward on this, and again, it doesn't necessarily mean how the decision is reached, but how's the budget determined for all the peer review and involvement of the designee going forward? And if that being the case, is there a, you know, does the applicant need to put funds in an escrow account for all the designee work that needs to be done throughout this project? And that being the case, you know, how do we determine that budget? Does anyone know what a budget might be for all the peer review and the designee reviews that are going to be done going forward?
So again, that is determined by your peer reviewer. However, if there is no condition in the document that provides for peer review, I apologize, there should be one in there, and I'm just,
Well, it is mentioned.
but is there anything in there about the amount of money that has to be submitted?
No.
So it should be, so
Okay.
I'll find that. I think I'll have.
At least I didn't see it. Ken, did you see it? I didn't.
That's not jumping
Yeah.
out at me.
Yeah, there's no line item there for,
Be towards the end.
okay.
So it's $20,000 it starts at, I think. Wait a second.
I didn't, okay.
But that night, wait, just give me a second.
Sure, yeah, take your time.
So
You got the room for 6 hours.
here we go. It is,
Excuse me.
okay, so it says, it should say, pursuant, that these, all of these peer review services and fees will be completed pursuant to 4453G. And so the, prior to clearing, grading, or construction, the applicant must pay to the town by certified check $30,000 as an advance.
I haven't seen that.
Is that in our document now?
No,
Oh, that's a
I
year.
don't know if it is.
No, I did
I'm pulling
not-
up a standard
Yeah,
condition.
I
It
did
was-
not see it. I
Okay,
did-
so we need to put this in.
Okay.
And then we would have to come up with a, a required amount. This one was the applicant will pay any additional cost to the town as required up to $50,000. And at any time, the amount of the advance is reduced below $5,000, the applicant has to replenish the account.
All right, so there's a payment that the applicants will make in advance. Does the board appeals, like we did on the first peer review consultants' contracts, we had to sign something, to sign the contract?
Nothing can come back to you.
All right,
That's done with the town.
okay.
Yeah, I don't have this money.
Another question was,
I don't, yeah.
there's reference to, throughout the draft, an occasional reference, on progress reports provided to the board, and requirements of the reports be forwarded for the board's review. So, and first of all, for those involved in construction, it doesn't mention it, but I would think it's best, that be the building commissioner's review.
So can you tell me what condition that is, or where that is, the progress reports provided to the board?
Well, as we go through it, we'll probably find it again.
Yep, we will.
Okay, because normally that can, I'd have to look at the exact condition. Normally that condition is there because these projects span years and years.
Correct.
And so, rather than the board having to chase the applicant or developer for an update, we require certain updates just to come into you. There's no approval associated with the updates, they're literally just updates that we have, we are 90% done with phase one, we expect to finish in March, something like that. So they're normally not,
Should they go to staff versus the board?
well, staff would presumably be monitoring the project anyway. The condition is meant for the board to be kept, abreast of what's going on.
So the board gets a copy of it, and if we feel the fact that we have an issue coming up there, we can make it an agenda item, discuss things, and then assign a board member to, make sure the town follows up. Or bring it to someone's attention.
Yeah, the building commissioner, again, the
Right.
building commissioner enforces the decision. But I'd have to see exactly how the condition was written.
Yeah, we'll get to it.
Well, it
Yep.
says something about reviewed and approved by
Right,
the
we'll get,
board.
Chris, let's go over that when we get to those. That's
I thought we were covering it now.
Yeah, if
Yeah.
you tell me the number, I can give you a better answer. I don't know what condition we're
That was one
talking
minute.
about.
No?
That's one of many, but go
Yeah,
ahead.
but let's just,
Well,
what's one
that'll
example?
cover all of them, right?
Yeah, go for it.
So 26.
Yeah, under plans.
Last sentence.
Well, that's any material differences identified by the board's designee shall be reviewed and approved by the board in accordance with 760 CMR 56.0511. So that means if there's any changes to what this decision approves, they have to come back to you. That's completely different than an update to the board.
Okay, yeah. There are some, we'll be getting to it.
So under 760 CMR 560511, that is the section of the state regulations that allow for the developer to come back for an insubstantial modification or a substantial modification. If it's an insubstantial modification, this board gets a request in writing for the change. You have 20 days to determine if it's substantial or insubstantial. If it's substantial, the public hearing process reopens and we start all over again. But we start all over again only looking at the change. But if it's insubstantial, right then and there, you determine it insubstantial and it's allowed. So that's completely different than just providing you with an update.
I think one is number 18.
Okay, so let's go to that one.
Which again, looks to me like it's just saying we have to be notified.
So this is so that the town can get units on the SHI. They have to notify the board when building permits are issued for affordable units and cooperate with the preparation and request forms to add the affordable units to the town's SHI. So that is, again, we need to know exactly, because of the fact that affordable units come on and off the SHI, they jump on and off depending on the time limit. So once this decision is filed with the town clerk, we get all of the units on the SHI for 1 year. And then a building permit has to be issued within that 1 year to keep those on. And with a project like this, it's very unlikely that a building permit's going to be pulled for all of the units. So we're going to have units that come on and off constantly. That's why that condition is there.
Let me ask the question on number 52 then, because the wording is different, because the wording in 52 said, shall be submitted to the board for review and approval. But if you go to 26, that Chris earlier mentioned, it just said, shall be reviewed and approved. That doesn't give me the option of saying no. I like the language, shall be submitted to the board for review and approval. That's in number 52 versus number 26. It says, shall be reviewed and approved.
So 52 is the same as 26,
And
essentially.
I'm going to submit that when we get to 26, I'm going to ask for an amendment to that language to say, shall be submitted to the board for review and approval.
But it has to say pursuant to 760 CMR.
Sure, I agree with that.
Doesn't it say that? I'm sorry.
No, it just says, shall be reviewed and approved. It's not discretionary.
It doesn't say shall be submitted.
So I guess I'm sorry, I don't understand the difference. Any
It shall
changes?
be approved versus we will have an option of approving it.
Right.
I don't know in 52 you have an option.
What it says?
Yeah, you
It
do.
just says submitted, but then it says
Submitted to the board for review and
for
approval,
review and approval,
which is what I want the number 26 to say.
but there's still a requirement. I don't think 52 says we can't review it at our discretion.
Okay, so we're going to say, so let's start with 26. We're going to say, any material differences identified by the board's designees shall be submitted.
To the board for review and approval, subject to or in accordance with 760 CMR, dot, dot, dot.
But do you think by saying submitted gives us the discretion to not review and approve?
Which one are you looking? I'm looking at 26. That gives us the option to review and approve it.
So the
Shall
sentence
says you
is-
have to.
So the sentence on 26 will say, any material differences identified by the board's designees shall be submitted to the board for review and approval by the board in accordance
Yes.
with 760 CMR 560511. So
Yes.
that same sentence will be converted to 52, which provides any changes to the, so the 26 is if the board's designee requires changes. 52 is if there's any changes to the actual plans.
Yes,
So we'll use the exact same sentence for 52.
yes.
Okay. Oh, I'm sorry. We will say, any changes in material or design not exempted above, and then we'll use the sentence from 26.
Correct.
Is that good? Okay.
And
But
Brian,
again,
oh, can I? Brian, while we're on 52, do you have a comment on 52? I think you wanted to add a word, you wanted to say significant changes versus any changes.
Yeah, hold on a second. Let me jump into the, my line items here. '52, yeah. The other suggestion was put in any significant changes. Use words, significant, or something like that.
I don't recommend that. That's too discretionary. How would you determine if it's significant or not? Any changes come to this board and you determine if it's insubstantial or substantial.
Okay, that's fine, I'll go with that.
Because if not, the developer's going to claim everything's not significant.
Yeah, I'm sure they won't.
Well, there's a chance, I'm not
Okay.
saying that.
Very good.
But just to clarify, so under either of these provisions, if anything comes to the board, one way or the other, we have to review and make a decision. It's either insignificant or significant. If it's significant, we
Goes to a
open,
full hearing,
it
yeah.
goes full hearing.
Yep.
Okay.
Guys, we did that several months ago for the Murray Lane.
Yep.
You know, they took down the building instead of trying to restore it.
Yeah.
It was determined it was going to be significant, so we had to reopen that 40B just for that particular item. So that's what we've done in the past, so it does work. Under finding of facts, just it's all under my questions. Do we need to list the site visits that were done by the board?
We can.
Okay.
Do you have them?
No?
Well, I have the dates, not with me, but somewhere,
Well, she's going to be drawing the document, that's why I asked.
but we didn't all go to the same one.
We were only two available.
There are 2 dates. Rachel, can you look back at the calendar at some point when the 2 dates that the board visited the site? And have that put in the finding of facts?
May 10th was one of them, because that's when I went.
May 10th and 17th.
There you go.
Okay.
And the 17th. Yep, 10th and the 17th, that right?
All right, all set to move forward? You get that, Amy? All set? Okay. All right, and last question, and again, you've already kind of discussed this, but in going through this document, and it's not that I'm a little familiar with what happens in the building department, but there seems to be a lot more tracking of compliance than I'm aware of that happens in a typical, development. So basically, on tracking compliance, I realize you have the peer review, but are they the principal person supposed to track compliance? Is that being tracked by the building commissioner? Who's tracking compliance throughout this document?
It's generally the building commissioner.
Okay. We'll get you a copy. Okay. All right. All right. Okay. Now we're ready for the first page.
Mr. Chairman?
Yes.
I might suggest, we didn't really talk about format for review. You're just going to do it page by page. Any questions on page 1?
I'm going to start off with...
Page 2?
Yeah, we're going to go by... Yeah, we can do that. I mean,
Because one of our board members may have a question on page 2 where we didn't.
well, that's true. We'll go through that. It's no, great idea. Absolutely. All right, so the first thing is... I'm sorry.
Brian?
Yes, Marilyn?
Hi. Yeah, as we talked yesterday, you had suggested that perhaps that if I had anything that I wanted to say about the project, that
Okay.
there would be a time early on in the meeting for me to do that.
I mean, that's fine. I can do that now. And just to keep everybody, Marilyn's off-site today. She's actually vacationing in another state. And it happens to have a lot of sunshine and more, warmer areas. So I talked to her, but she might be able to take an opportunity to kind of indicate what her concerns were and so forth, to express them, and then she'd be exiting the meeting, okay? All right, so Marilyn, you have the floor, but thank you for reminding me.
Thank you. That's okay. Since I'm not going to be voting on this project, I appreciate at least the opportunity to make some comments about it. I am sorry that I'm not there. I mistakenly said I would be there today when I won't actually be home until tomorrow. And I also want to say that I'm very appreciative of everyone's very serious effort, very diligent over these many months to understand this project, and particularly I want to thank Brian for all of his effort. I want to say that I am a strong proponent of affordable housing. The present lack of affordable housing stock is a serious local and national issue that keeps people poor and hamstrung. I believe that the developers of this project are endeavoring to cut a very large swath out of our need. I have no reason to think that they have anything but the best of intentions, and I applaud their efforts to carefully tackle the technical aspects of the project. As proposed, what this project has failed to accomplish, in my opinion, is give it a pulse. It lacks heart. It is maximum people shoehorned in without those things that create healthy community. It does not create natural opportunities for healthy gathering. While being set on presently undisturbed wooded land, the project will be an environment that is not inviting, it will be alienating. Where are the front porches? What parent will be able to, from the kitchen door, keep an eye on the children as they play outside? Where would a kid even ride a bike here? Surely not safely on narrow streets with cars lined up on both sides all along the way. Or could anyone take a serious walk without trespassing on private property or along an industrial zone? Where are the services that every thriving community offers? Where will the cafe be, the bakery, the soccer pitch, the baseball diamond, the library, the barber shop, a pharmacy, the piazza? Community happens when people have places to see and be seen, know and be known through a pattern of both the routine of daily life and intentional social gathering. Harwich spent a sizable amount of money and effort to do a housing study. That study spoke affirmatively to the antithesis of this project, named sprinkled affordable housing. And yet we seriously consider this. Social scientists since the mid-60s, if not earlier, have told us what makes high-density living without organically designed and integrated services and opportunities for interaction of residents do to the soul. This project is a Cape version of Cabrini Green. In my opinion, no matter the good intentions, this project will not be the idyllic neighborhood as pictured in the developer's marketing materials. The large buildings, euphemistically called lodges, as if this were a national park, will turn out, I fear, to be simply warehousing of bodies. I do not believe it will encourage holistic well-being, and therefore, even though I won't be voting, I could not support this project in its present form. And those are my comments.
Oh, thank you, Marilyn. It's been much appreciated.
Okay, thank you all.
All right, move forward. Just looking at the first page here, I think everything's listed properly. Correct? Okay. All right, under background. First paragraph, the public hearings were open on April 24th and then continued to June 18th.
So that's a change, Amy.
That's a change.
Got it already? Yep.
Okay. On the fourth paragraph, I don't know how you want to, this is regarding, well, anyways, the fourth paragraph, the 5 full members have not missed any meetings. I don't believe so, correct, guys? However, Marilyn Ratz, the alternate member, missed the April 24th hearing and complied with the Mullen Rule. So I don't know, just want to let you know about that.
Delete the paragraph.
Just delete the paragraph,
Yep.
okay. Anybody else have any questions on background?
No.
Okay. Submittals. I just want to make a suggestion that Rachel and Christine, before the final document is printed, they say that they verify all submittals are included in the decision,
Yeah, yeah,
okay?
we struggled with this.
All right, so
I think they're all there, but.
Rachel and Christine, I need to have you verify all submittals, at, at your earliest convenience for the final, when a final decision is printed, and make sure that everything is in sections A, B, and C.
I also didn't know what the board wanted to do about all of the public comment letters. So they're not listed. Would you like to just do a catch-all that says, in addition, the board received numerous submittals from the public? Numerous comments from the public?
Will they still be available on the town website?
They are on the website now.
Going forward?
No, because the page will probably eventually need to delete all that information. If you guys get another huge, 40B in or something, I don't
There were,
know how long.
I would say, I was very impressed and pleased with the response in the community and all the people that took the time to write letters. So my recommendation is that we list them, we don't get the content, but we list all documents received from the public.
So we'll add section D.
Section D,
Okay.
because there was, I think that should be, should have a history of that, and there's, again, a lot of thoughtful and comments. Particularly took a lot of time for a lot of folks to dive into this, so let's make sure that's recorded, the decision.
Yeah, if it's not going to be on the website going forward, I think we need to somehow record who put things in and.
Yeah, absolutely. I think it deserves to be on. Okay, so
What do you envision? Just name, date?
how it's listed right now, it's fine.
Yeah, the name and the date, that's how
name
it's
and
listed
date,
now.
Period,
Yeah.
right? No pro or con, just.
Oh.
No, it's
Feedback.
just wanted to get the listing out there, okay? And it's already a matter of public record, so I don't believe it's an issue for anyone who sent it in. It's on the website, okay? So I have to make sure it gets recorded. Okay. All right, that completes the background. Anybody else have any thoughts or questions?
No.
Okay. All right, findings of facts. The only comment I had was regarding just record of the site visits. Does anyone see any findings of facts that was missing?
There's nothing regarding site visit in the findings of fact.
Right, we're going to add that.
Where would we add that? There's nothing about the dates or anything.
We just discussed the dates a minute ago.
No, I
May-
added that to background.
Oh,
That's fine.
that'd be fine. Then that's great. They can be in background.
Okay.
All right. Thank you. Just want to get that on the record. Decision, item 4. Complete list in section 2 on A, which is the approve the site development plan number. we need to get that in there. I know we brought the plans here. Do we need to sift through and find that plan number now?
No, you're on decision?
You're on page 5,
Yep,
item 4, decision.
yep, decision, yep. So it would be,
I think it's referring back to, right?
yeah, but we can add it right there. We can add it right in the decision. It is,
We're just trying to figure out what's put in that blank.
yeah, we have it. So it's listed in section 2.
I don't think there should be a
A-
blank, is what I'm saying.
Yeah.
Oh.
soon.
Should be 2B probably, right? 2B, and it should be probably number 19. Add the final plan. I'll add the final plan and the date.
No, revise it to-
Yeah.
Yep.
Don't you think revised instead of the application?
Yep.
Okay. Okay.
Boy, I'm glad we did this report. Okay, on to item 5, conditions of approval, administrative. Under 1, under administrative, what is its limited dividend successors?
If it's a limited dividend organization, if the organization turns over to another organization, it's the successor, it's the next organization.
Okay. All right, so if they sell all or portion of the investment, does a party need to be approved by either the ZBA or the state?
By the state.
By the state, okay. Item 2. Except or otherwise, can you just explain this process on item 2?
So what this is where submittals are supposed to be submitted to the town. They can go out to peer review. So we specifically require certain things that go out to peer review.
Okay.
So that's where it says except as otherwise specifically provided herein.
Now, gentlemen down from 3 to 11, I had no comments. Does anybody have any comments on those sections?
No.
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 Okay. All right. Item number 12. Getting into the project shall comply. I would add except as waived or conditioned by. So
It already says accepted, where you can't.
it says except as waived, but I would add or conditioned.
Could we have waivers as well as conditions?
Everybody on board with that?
No, I'm not. I don't understand where we're saying it.
Okay, hold on a second.
So-
At the end of the very first sentence,
Eh, eh,
Amy.
Except as waived or conditioned?
Yes,
Okay, got
by
it.
this decision.
Thank you. Okay, got it.
I had no comments from 3, from items 3 down to 3 and 14. I had no comments. Anybody?
No.
Okay. All right, housing. 15 to 16, I had no comments. 17, okay, so here's where I get a little confused here. Now, Amy, you're showing midway through the paragraph, we indicate the 70%. All right. So I'm questioning, my question comments is on the percentages. All right, so throughout this process, obviously, I've been hearing, 242 units, and I believe the number I always heard was there's going to be 192 affordable units. So 70% of the 242, I'm sorry, 192 out of the 242 comes to, over, close to 77%. But when I went on to, which is on page 8, and for the first time, I actually added up on each category, 30%, folks look at the schedule there, 30% category, the full 50%, 60%, 80%. Those numbers, 55, 18, 91, and 29, they come to 293, they come to 193, not 192. So it's like for the first time I heard an extra affordable unit, which is great, but I have 193. So if we're using that 193 number, then that would be basically 79.7% or 80%.
You're talking about that 70% and about the fifth line down?
Yeah, in the middle of the paragraph, yeah.
That talks about the initial renting period.
Even more,
At the very end of that sentence.
even more specifically, Brian,
Oh, it now goes on below 80%. I'm sorry, you're right.
70% gets local preference. 80% will be affordable, which is 190
All right,
units.
okay.
Of that, 169 will get
All
local
set.
preference.
Now I understand it better. Thank you.
But again, the 80% is what makes, 80% of the average income.
Oh, less.
80%.
Right.
It's not 80% of the
Oh, no. Oh, yeah, so we have, all right, so that's 80% or below. That's correct. Right. All right, so 70% is what gets local preference.
Correct.
The initial,
It has nothing,
initial period.
it has nothing to do with, excuse me, thank you. So I was off, I misunderstood that. Okay. This is why we call it review. Okay. Thank you. All right. I had no comments from 18 through 19.
You asked number C on 17?
I can't hear you.
You had a
Oh, wait a minute, yeah, you had a question regarding, there's nothing designated in this thing for Section 8, correct? I didn't see that, yeah, okay. The question that came up. All right, 18 and 19, I had no comments. 20. I don't really fully understand local springing regulatory agreement to be executed with the town. When is it executed, and who's responsible for drafting it?
We draft it, KP Law or your town council will draft it, and it is signed by the select board, and it takes effect once the subsidizing agency's regulatory agreement expires.
And when is that?
That's the 50-year discussion we had.
50,
Oh, that's, okay,
30, 99,
All right.
it's all different.
okay.
So this is the in perpetuity.
Yes.
Okay.
So just want to be really clear for public as well as for myself. If we approve this, we're approving it subject to it being affordable into perpetuity. Is that correct?
That's what the springing regulatory agreement will provide.
So yes.
Yes.
Okay,
Yes, thank you.
all right, okay.
Unless there's a modification that's granted by this board.
21 and 24, I had no comments. Anybody have, on those, going over it?
No.
Okay. All right, 25, just a clarification. I know, which is, obviously I'm fine with it, no apartment can be rented for less than a one-year lease. But often, as far as the rental agreements, at the end of rental period, the people can renew, and they negotiate that, and sometimes people are allowed to stay on for a period of time as tenant at wills. Right? How is, on a 40B, on this type of project, a development, how is that handled typically?
I don't know. So we put this in because it's important to the town,
On a one-year lease, is
have
right.
long-term rentals.
But after that, the developer will have, if someone's already on board for a year's lease, then how they negotiate as far as extending it, that's up to the developer.
Same way any
Yeah.
apartment that's done. Most apartment I've ever rented was for a year,
Right, but then you,
and I got out of many of them in a shorter period of time. But
Right.
there's usually in there.
Just wanted to-
The developer will have something in there about that other thing.
I just want to know the fact that they're not being, people, because people's family situations can change mid-year after the first year, renting, and I didn't want them locked into a full year because, they have to make a family change. Okay, so that's not,
To avoid short-term rentals.
yeah, okay. So after that, they can go forward and do a normal type lease programs, okay. Again,
Really, I'm
it's-
trying to confirm if this would even be allowed by UHLC.
okay,
So this might come out in the final version, I'm not sure. I'll see what they say.
okay, thank you.
So it's, obviously the intent's not to do this, but if this comes out, they could rent this thing during the summer for 2 weeks.
No, so if you look at the remainder of the language, says that none of the units in the project shall be used or offered for use as short-term rental defined under 64G, which is less than 31
So
consecutive
that's
days.
allowed. But the
I think-
12-month
I think
minimum
that-
might not be.
I think that the second part of this condition would be allowed more than the first part.
Okay?
Because the town, under 64G, the town does have the right to regulate short-term rentals.
The second part's probably more important than the first.
I think so, but I think we try for
Right,
both.
okay.
Okay. After we go through this next section on the plans, I think we're going to take just a 5-minute break,
Good idea.
okay? All right.
Home agreement.
Line 26.
That's been fixed.
Okay, that's okay. 27, 28, I had no comments. Anybody have any comments on 27, 28? 29, I had a question of board's designee, but I know that's now the peer review. And 30 to 32, I had no comments. Does anybody have any? Okay. Okay, 33. All right, so that indicates that no construction upon the property shall begin prior to pre-construction conference. All right, so one, what was the purpose of the conference? I can appreciate that, to go over the construction. And is this going to be required with every phase, 14 days before it commences?
It's usually not. If you want it to be, we could put that in.
Because the length of time here, I think we should. That's my opinion. I don't
The
even...
only problem that we have there is there going to be overlap of phases.
Then there'd be an overlap of the conference. They can just...
Okay.
What's the
So-
purpose of the conferences? Multiple times?
I don't have it multiple times. I have it just the
Yeah, I
once.
know. To Brian.
Well, I'm assuming, again, that when this is going to start each phase, since this is over a 10-year period, there's bound to be, first one, personnel changes in the town, personnel changes with the consultants, and I think the people who are on the peer reviews and the people who are on board in key positions in the town need to get familiar with the whole thing, and then we're required to have a sit-down and go over, okay, what's happening next in this next 2 buildings going up, and what's the plan? I mean, that's...
Do you want to say something to the effect of, based on based on the proposed phasing, the building commissioner may require additional pre-construction meetings prior to each phase commencing.
Oh, absolutely, that sounds good.
That's great.
I
That's
don't
good.
remember what I
That's-
just said, though.
Well, we have it on tape. We have it on tape,
Okay.
so you can go back on that.
Good. All right, I will. All right.
Perhaps the commissioner, you know, after the decision is reached, can send you some language as well. Okay. F, oh, sorry. All right, one other question. Boardwalk. This is again on the
You are on
third.
34F? just-
I'm still on 33, excuse me, I'm sorry. Where did I make a mistake here? Okay, no, okay, wait a minute. It's in the wrong place, okay. Under 34, again, it's, I know the designee is now. Under 34, I had a question on F.
No, I think that's a leftover from another permit. I don't recall a boardwalk.
I don't either, so that's why I wanted to,
I'll delete that.
Delete.
okay. And with that deletion, I just like to just call for a 5-6 minute so break. Okay? It's now 10:28.
34F.
We'll get together at 10:35.
There is.
Thank you.
Christine?
Just before we start, I just want to make a comment that I can appreciate there might be some frustration from folks that are in the audience, the fact that you don't have these documents in front of you. It's a deliberation situation, it's not a public hearing. That, therefore, these draft documents that we're using for deliberation are not made available. All right, so I can appreciate, as I'm going through this, that it's kind of hard to follow.
Mr. Chair.
Oh, wait a minute, the draft is?
We will post these documents at.
Oh, I'm sorry.
At the end of this meeting.
Okay.
And they are, town council.
I thought it was public, public
say
stuff, we
that
did the
these are
decision.
public documents.
Okay, I apologize.
Brian, just to clarify, we found on the drawing, there is a boardwalk.
Okay.
That connects buildings, large buildings 2 and 3.
So that paragraph will remain?
Yes, I would recommend that paragraph remain.
Is Rachel around? I take, guys, just give me 3 more minutes. So it is a public document, correct?
Yes.
Right now,
Not how you want to get here. Didn't die.
Fine, just open it now.
No. Yeah, glancing gold, I think. Yeah.
So when we go from Shrewsbury up to New Hampshire, I go the back way, which is 13. It comes out of 190 comes out of the city of Worcester. I mean, Worcester, straight up.
I turned Texburg at one year in my life. I was going to take up 13 down a country road, snow covered. I had a condenser looking at my deer stand.
Go through
Lunenburg up to not there's one there. I just
Son, he's in Lunenburg, but
I think he's on the hill beside you and lands on my hood car. I was out. I don't think.
when I come up, he's in Lunenburg. It's a good, decent-sized town, you know. But that's what Dean is. But we shoot right through them. It takes maybe an hour. Son's house in New Hampshire, it's the back up. I will not go to Boston. No chance, not a chance. Probably couldn't drive it. There's nice towns, there's towns in the whole series of towns.
I was going 60.
Small town.
And this cat runs around. I don't know who the gas is starting out. And I look in my rearview mirror. I heard a couple. I look in my rearview mirror. The favorite slide is like, oh, that one's done. That one's toast.
Time we left the Cape of Shrewsbury, the time we left Shrewsbury, New Hampshire, nothing. No traffic.
Yeah.
I was shocked coming off the Cape. We left at 8 o'clock in the morning on Thursday. Yeah, we left at noon, quarter to 12. Yeah. And there were vehicles, we did not slow down once. There was no, ever had to hit the brakes or slow down. Yeah. At 8, I wouldn't expect anything. It wasn't. It was, we leave early. We went down this road before. Yeah. And, I just didn't want to, my sister, I didn't want, she didn't eat till 4.
Oh, my.
Okay.
I wasn't even sitting there. They finally tracked it. They said, dude, you guys got to stop that.
I just want to stop. Well,
Wow.
not so much that.
That's hilarious. That is
I
funny.
think a drink of soda, but, yeah. But football games out of them, so that's okay. Yeah, I got to watch the big one.
I know
got
this
some,
guy's about to shoot him, I know that.
That are 30. You know, yeah.
So they're all into football.
Oh, yeah.
One of them.
Okay, so the
75,
the main printer is down. So what I've requested we do is that it's being worked on right now, and I apologize, I hadn't realized that during the meeting here, that they were public documents already. That being the case, my review, I've asked for copies to be printed up for everyone to hand out, and when the printer is back up, also at some point here during this discussion, we'll have some drafts printed of the draft decision. Okay, all right. So where do we leave things here?
We just finished 34.
We have to go back to boardwalk, correct?
Yes.
We just said that stays in because there is a boardwalk
Okay.
on the final plan.
Okay. All righty. '35 to '39, I had no comments.
The only comment I had, Brian, on number 36,
Yes.
you know, I'm fine with the 7 AM to 7 PM, but I think, is it clear that that includes like delivery, other activity? It should be all activity at the site, right? Not just, I
Deliveries,
know we say deliveries, trucking and everything like that, but,
It says deliveries, excavation, trucking, and equipment startup. I think that has to do during the construction phase. But you're saying, so during the construction phase, you want people delivering materials before 7, I think.
absolutely, well, because,
I agree.
you know, in construction, a lot of times movements of equipment try to happen before, roads get busy.
Yeah.
So I think just, I withdraw the question, but I think it's just to be clear that it's 7 to 7.
do you want me to say construction activities, including but not limited to?
Yeah, I think just to broaden it, that, given that there's a residential contingent nearby, somebody showing up with a large excavator at 6 o'clock in the morning for delivery.
All right. Uh, 40 regarding soil testing. I think during construction, applicant shall test all soils and fill materials brought to the project site to ensure quality. It's a minor situation here, but one discussion we had was to having the soils tested before they show up to the site. So tested at the source, not tested at the site. So I would adjust the sentence to say that applicant shall test all soils and materials to be brought to the site to ensure quality.
Or you want to say prior to being brought?
To be brought, okay, prior to be, prior. To test all soils and materials prior to being brought to the project site to ensure quality.
Okay.
40, 42, application to ensure reinfiltration of the property of all groundwater. That's all, I have no questions on that. 43. There are no apparent issues here, but at one point, and just to make sure we didn't make any agreements, I don't believe we did verbally, or discussion, I recall the applicant regarding self-inspections, which wasn't really a big fan of, but just want to make sure we're all set on that.
John,
It's
do you
not
have any comment on this?
No, I think I'm good on this one.
I mean, the self-inspection's not self-inspection, right? It's actually an independent agency that inspects a different organization, right?
Well, I think, and I'm not sure if it's the same discussion Brian's thinking of, is that there are a lot of required inspections, particularly with regards to the wastewater treatment plant and stuff like that, that are already required by law. So I think there was a discussion about not inserting anything, supplemental that's already required and governed by another governing body.
Okay.
I don't think we need to create new,
Okay.
This is also gonna be the paragraph that we add in the money.
Oh.
That we talked about.
Okay.
So it says here, provide funds necessary to complete the inspections and shall supplement said funds when necessary, so I'll add the amounts.
Forty-six. I'm sorry, excuse me, I'm sorry. 44 to 45, I had no questions. Anybody have any? I'm going through that report.
No.
46, surety instrument. Why require a bond for landscaping? If required, what would that, how much would that be for?
Well, it's for the landscaping that has not been completed. It allows them to move in prior to the landscaping being completed. This is a standard condition that I know Judy and I have been putting in our decisions for years.
Okay.
Because if not, the landscaping doesn't get done.
it's like if they get the
Yep,
CO
okay.
in November.
Yep.
Exactly.
and they
Right,
can't do
you can't make them
landscaping
wait until
May.
April,
Yeah.
yeah,
All right, then I just want to there's a little typo in the middle of
Sure.
that, in
sure.
6 lines down, where it says applicant's reasonable estimate of the cost, TOT, complete such, I think it's supposed to be 2
Sure,
versus
thank
TOT.
you.
That's it.
All right, 47, construction sequencing plan. Why is just a conservation commission or board designee involved in ground disturbance and traffic management plans? I mean, it gets into, we're not bringing in other, besides the conservation commission, we're not designating building inspector or maybe building commissioner and so forth, just those two bodies.
This
But-
has to do with stormwater, that's within the, within the applicant's SWIP, and the construction traffic management plan, which is basically, during the ground disturbance portion of this. We can add the building inspector, or building commissioner, I'm sorry, if you'd like to.
I don't think that was your point, was it,
Oh, what? Oh, sorry.
Brian?
Well, no, it was, in a way. I mean, in fact, we only get those, just the Conservation Commission, which is strictly involved in that. I didn't,
Board designees are plural,
Yeah.
right? So I mean,
It could be the commissioner, or building commissioner.
And they're just getting a copy, there's nothing they have to do, they're just merely receiving notification.
let's add the building commissioner in that if we could, just so, make sure the building commissioner gets the copy of the sequencing plan.
designees.
Yeah, but right now, we've used the term designee to pretty much focus on a peer consultant, DVH. I'd rather make sure that we're specifically indicating that the building commissioner should have a handle on the construction sequencing plan.
Agreed.
I had no questions on 48. 49. What is the budget expectation of fees? Again, I think we've already kind of discovered this, we went into this earlier, but the applicant should pay all reasonable fees imposed for the purpose of post-permitting, so that's being addressed, correct, Amy?
Do I have changes to this? I don't know.
No. I
don't-
mean, yeah, obviously, that's it.
This is, so, you're gonna have peer review fees for the review of the plans prior to construction, that the plans that they're gonna, so these are preliminary plans. They have to provide construction level plans to the town. Those can go out for review. And then during construction, there's also check-ins, things like that, that your peer reviewer can do. But then there's, after construction, there's stormwater management, things like that that have to be inspected. And that's what this paragraph is talking about.
Okay.
There's a typo right at the very, at the last sentence. It says thereafter, no occupancy permit shall issue. I'm sure you want to say shall be
It
issued.
shall be, right.
Last sentence.
Sounds good to me.
Sure.
Fee or bill.
Shall be issued, yes. Did you see another one?
I was just thinking where it says that, next word, couple words after that, if an outstanding fee bill, probably fee or bill.
Got it. Thank you. Okay.
Okay.
No question on 50 to 51 regarding the final plan sets and so forth. Anybody have any questions on that? Okay. I think we already reviewed 52.
Yep.
'53 to 57, I have no questions. Particularly, I'm pleased to see 57 in there, that no stumps or construction debris can be buried or disposed of on the project site.
So, 58, I need help on 58. I'd like you to do that because of the length of, the proposed length of this project.
Yeah.
I'm not sure that this condition is adequate. It says, if construction is not completed within blank months of the issuance of the first building permit, a revised construction schedule shall be submitted to the board. Usually that's about 24 to 36 months that we put in, but here, it's gonna be
Years.
120 months, right? 12
Yeah.
Yeah.
times 10.
That's why I said,
So do we want to do 65 year? I don't know how we want to do it.
well, all right, so my comment on this was that, should we request a revised schedule after each phase is completed, and perhaps within 18 months of the initial building permit for each phase, if construction is not completed for that phase? I mean, just so we, this, again, talking about the reasonable time for submitting a revised construction schedule. So if they're not, as each phase starts, if they're not done within a year and a half of what that phase is supposed to be completed by, at that point, they have to submit a revised schedule.
I mean, if they would probably be doing that anyhow, so it's just submitting something they already have in the background for their project planning. So I'm thinking, adding that, something along those lines shouldn't be a...
I mean, the building commissioner is gonna need to know, get a handle on what timeframes are gonna be.
What if we said if construction is not completed within 18 months from the issuance of each building permit for this project, a revised construction schedule shall be submitted to the board and building commissioner? So
I know-
each time they file for a building permit, they have 18 months to complete the work under that building permit, or they have to send,
I think you need to go a little further than that. These things are not gonna be done in 18 months.
So-
I'd say at least 24 months.
Well, at least, I don't necessarily agree. I think, I'd rather the shorter period if the, or why don't we add, or 18 months, or to the discretion of the building commissioner. That way,
Well, but I think as presented, it's 2 years. Right? It's 2 years per phase.
5
true,
phases,
there are-
10 years.
yeah, that's true, there's 5 phases.
That's what's
Yeah.
been presented.
I think 24 months makes more sense.
all right, I think, given that rationale, I
The way
appreciate
you
it.
worded it, the way,
Yeah.
per phase. 24 months with, per phase. Okay.
Rachel, do you know if the printer is still down?
Which printer, or,
The main one?
I don't know.
Okay, it was, I checked a minute ago, and I thought, if you came to my, thought I might be able to provide some of the draft plans to the people in the audience, so. It was down a few minutes ago, that's why I was checking if you,
I don't know anything about
okay. All right. When you have a moment, if you could check on that, because I would like to have,
Are we talking about the large plans printer?
no, the regular copier.
He just wants to supply this decision to people.
Okay, I can print that out.
Okay, so we've got, I don't know, 15 copies?
Of this and his memo.
Okay.
18, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14,
Okay. Okay, all right, where am I at?
59.
Calendar days,
I had no comments on 59.
That's all of them, everything, yeah, every.
It's regarding the infrastructure. We're on infrastructure and utility management at the moment.
The only question that I would have on 59, and I'm not exactly sure I understand the context of referring to Queen Anne Road, given the options we discussed at previous meetings of having a connection to Main Street,
Yep.
do we need to refer to Main Street as well, or just to any public road?
Any public road sounds probably.
I think you're right.
I think rather
Yeah.
than calling out Queen Anne,
Yeah, that's why I highlighted it.
Yeah,
So
okay.
do you want to just do?
I think any
Any-
public road.
Any public road.
way?
Yep.
Okay.
Sure.
60. All right, prior to the issuance of a building permit, applicant shall submit to the management plan, should submit a management plan to the board for their review and approval, which shall be maintained for the life of the project and shall include whatever. I'd like to have that include, the building commissioner as well.
Because Amy, didn't you
It's
say?
actually just, it's for your review, it's not for approval.
No, I realize that, but at
No, it
least,
says approval.
I know, we have to delete that,
No, I'm just helping Brian.
oh, does say approval, right.
yeah. So
Okay.
you want to say prior to the issuance of the building permit, applicant shall submit a management plan to the board and building commissioner?
Yeah,
Okay.
all right, get rid of approval, yeah.
And I know it's sort of addressed in the next paragraph 61, but again, there are other regulatory bodies, like particularly with the wastewater, that will require a maintenance plan.
Correct.
So is this supplemental to that? Or is it, specifically number A, where it's specific maintenance
The
responsibility?
stormwater system operations and maintenance plan, that's required.
Right.
So that, yes, that is, they have to be responsible for conducting annual
But for
inspection.
the
and all that
sewage
stuff.
plant, they're gonna have to
Oh,
have a
that's different.
separate
This is for
maintenance plan,
stormwater.
Right?
Yep.
So when we say specific maintenance responsibilities, are we talking about the buildings themselves, the
Yes.
occupied buildings?
Yep.
Should we call that out, given that there's
So.
other maintenance plans that are gonna be out there, right?
Shall submit well, it also has to do with delivery and vehicle, things like that, moving in. So,
I kind of like it because it's all encompassing right
Mhm.
now. Otherwise, we start putting in building and we forget to put in
Yeah, no, I
dumpster
agree with
storage.
you, but I think, you know, again, I don't wanna see the duplicative either, right? Or can they incorporate by reference in these maintenance responsibilities, just things that are covered under other plans that are recovered by governing bodies, right?
what about a site, a property
Sure.
management and operations plan or something? Does that sound better? But it does not have to do with the stormwater or the
Or the
wastewater
sewer,
treatment
yes,
plant.
I'm just
yeah.
with the way this is, the thing's not covered under, or something that says not covered under
Okay.
other plans.
Yeah, we
maybe,
could do that.
Oh, yeah, not covered by other plans.
you know,
Or not covered by other maintenance agreements.
Well, I'm sure they'll have, I'm thinking more from a regulatory standpoint, right, where they have to have, you know, again.
Not covered by required operations and maintenance
yeah,
plans.
They're
Okay.
gonna have to have one for the sewage plant.
Yep, and the stormwater.
Excuse me.
Not
So it's gonna
otherwise.
be, the applicant shall submit a management plan addressing components of the project not covered by required operations and maintenance plans.
Let's do that.
Okay.
Okay. Brian, down to 61?
61, okay. 61 and 62, I had no questions.
I have a question on 62.
Okay?
The project shall connect to the town of Harwich water and sewer infrastructure, as shown in the file plan. There is currently no sewer infrastructure.
Yep.
But if you look at the town website, this will be the next phase, sometime around 2030. So do we make a requirement that they do connect to the sewer?
No. We.
That would be separate.
Right, that would be
The
separate.
town would have to handle that.
Yep. Right now, they're proposing a wastewater treatment plant, so we need to leave it at that.
So do we delete the sewer
Yep,
reference?
delete.
Right, but I mean, the future, even though they have the plan, in the future, there will be sewer.
Yeah. But they're gonna have their wastewater treatment plant, so we can't require them to then connect to sewer.
Okay.
So we
I'll
need to
remove-
eliminate sewer from this
Yep.
paragraph.
Now, there was also something that, for the sewer system, they're doing it in phases. Phase 1 will be basically an enhanced Title V, and then at Phase 2, they're gonna put the full system in.
Correct.
And probably due to the flows, they have to have that by Phase 2, and they said they're going to have that by Phase 2. But there's a lot of concern, obviously pollution, any kind of overrun or anything like that would cause a problem. Is there any way we condition in here that they cannot occupy Phase 2 until the full system is up and running? They said they'd do
Yes.
that already.
Yep,
Just make that a condition?
sure.
That way we know it's operational by Phase 2. It's a condition.
Right? And
By
then
the
we-
end of Phase 2.
By the end of Phase, before Phase 2 can be occupied, they must have their sewer system up and operating.
I agree with that, but I think, again, why I had asked them to provide a little bit more technical information, because I still think there's confusion, is that the system that they're building, the Title V designation is just a capacity designation.
Okay.
The system that they're building will be a full processing system in Phase 1.
Correct.
It's just they will add additional capacity to it as the phases come.
And there's probably some other components because of the volumes
Title
and...
V regulates things with a capacity below 10,000
Right, okay.
gallons per day. So that's why I think there's been a lot of confusion about that. It's
Right.
not two different systems. It's one system that
Right,
just added
correct.
capacity.
It's
Yeah.
correct. But I think it's not like adding another
But I agree
block.
with the capacity has to be added before you allow
Right.
occupancy, but it's not like.
Yeah, I mean, this system's gonna be as good as any
Yeah.
sewer system made.
It'd be better than any.
It may be better than the town in the end, because they say essentially zero. You can't say zero because it's, one molecule means it's not zero. So there'll be something that gets through, but essentially, no, probably not really that detectable or below all kind of regulatory limits.
So Amy, you're gonna add the condition that says that the wastewater treatment facility must be completed and operational prior to occupancy permit for phase 2?
So, yeah, so I have, prior to phase 2, the wastewater treatment plant must be approved and operational, before CO. But then I also have, and must be, something for each subsequent phase, because are you saying that the wastewater treatment plant is going to change every time there's a phase?
No.
I
No,
didn't
my
think so.
understanding is in phase 2.
Oh, okay, so then we leave it at that.
To handle
Correct.
all the capacity.
Okay, so we'll leave it at that. So it's gonna say, prior to occupancy permit from phase 2 issuing, the wastewater treatment plant must be approved and operational.
Period.
Correct.
Okay.
Good addition, Chris.
And I think that's probably going to be required under the plan they anticipate.
I don't think the flows will allow them, right, but, yeah.
Okay,
On 63, Brian?
in 63. All right, 63. All right, so 63 gets discussion of,
That, 63 should not be
It should be
involved
doing
here.
that if they were connected to a sewer system.
Yeah,
I believe
that's not,
this
that
will.
doesn't belong here.
okay, all right, so no wonder I had a question on it.
66, I didn't see any fire department conditions, but I put that in just in case, so if anybody remembers any, I went through all the documents, I couldn't find any.
And the fire department, the chief, both the chiefs of the police and fire department signed off on the final site plans.
Right, okay. So that'll be deleted.
Okay, on to stormwater management. Obviously, the applicant will comply to the stormwater management plan as shown on the final plans. It's 66 and 68, same, I had no questions on that. Anybody?
My question is, don't they sort of, isn't that sort of a circular argument, right? Because you have to get the state permit, right? So, I mean, if you have a state permit, you have an approved plan, right? So. one
You're
or
just
the-
saying it's
one or the oth-
redundant?
Yeah, one or the other doesn't apply, right? I mean,
The state doesn't give a stormwater management plan.
The
Well,
applicant does.
what's that?
The state doesn't issue
But it has to be approved
stormwater
though, right?
permit. No. The
No.
wastewater facility has to be approved.
I thought the SWIP had to be approved also.
The SWIP has to comply with the applicable federal and state regulations. NIPDES is a self-regulating program, so they basically just have to fill out
But
their
if-
general notice of intent with NIPDES, and they, once they
If you've
apply, they're
complied on-
good.
If you've complied on 68, then 67 would be true, right? You'll have to comply.
Yeah,
Yeah,
but
that's kind of what I'm saying, is it is.
You're
redundant.
saying delete 67.
no, we shouldn't delete either one. The applicant shall comply with the stormwater management plan as shown on the final plans. That's the stormwater basins, the infiltration beds, things like that. And then the applicants have to comply with all applicable state and federal stormwater permitting requirements.
Those are different
So
things.
they're two different things. If
Yeah.
if Mass DEP comes up with different requirements, they have to comply. So I think we should keep them both. I
No,
think
I
they
mean,
can,
but those-
they'll clearly achieve both.
They'll have to be
Yeah.
on the final plans,
Yeah.
right? Whatever the state says.
Yep.
Brian, 69?
Yeah, it's regarding where the snow's being stored, and it's on landscaping plan sheet, and I don't have that sheet number. Christine, any
We can
chance
look
you can?
after I didn't have it, I couldn't find it on the plans that were online, I couldn't find it.
It's probably on
We'll
several
follow that,
sheets.
yeah.
Okay,
It's probably gonna be
I think
on
it's
the building
referenced.
by building
okay.
sheets. It's probably gonna be more than one sheet.
Okay.
Designated.
Christine, can you get those numbers to Amy, please?
Yes.
All right, thank you. Okay, stormwater management conditions. On A, just suggesting, wait a minute, why did I make that change?
You wanted the conservation agent to receive
She
a
gets it
copy.
in a previous condition, so I'll add her.
I want to add the Conservation Commission, the Conservation Agent.
Yep.
Getting that plan.
Mhm. I had other questions on 70. Anybody?
Well,
No.
A should have 3 Ps.
Yes.
SWPP.
Oh, sorry, the second one, yep.
Oh, yeah. '71, on maintenance, I had no question what's on that. Anybody? And I had no question on 72. '73, on that paragraph, just suggesting on the last sentence, shall be provided to the board or its designee.
Sure.
So you just want to add the words, "or its designee"?
Yeah, or its designee. Okay. All right. Two conditions I thought were missing was that the direction of the groundwater flow to be established with a hydraulic study, which is required by the state for the wastewater treatment portion of the project. It's not specified in here. It was a condition we discussed on the 15th.
I think that's required. isn't it?
So Christine and I were talking about that during the break. That is required by Mass DEP.
Okay.
Part of their application for their wastewater treatment plan.
So it does not need to be in the decision.
We could put in for them to submit a copy, is that,
Please do.
okay, so
Because it will be done, correct?
Yeah, they have to do that,
it
right?
has to be done.
Just want to confirm, otherwise
They,
you can't
they
approve
told
it.
us, I don't know for certain, but that's what they represented
I
to
know
us.
it's- Well, I think our consultant confirmed
Yeah.
that as well.
I mean, I would assume so with a wastewater treatment
So
plan.
just
So-
a condition requesting a copy.
Okay, so,
Yes.
Yeah, I'm fine with that. And also that the annual reports on operation and maintenance plans for the stormwater management system be submitted to the town of Harwich.
Biannual would be BI dash, wouldn't it? As opposed to BY? Yes. Biannual?
It should be, but
Where are we?
did we mean twice a year?
If they're getting them twice a year. We just want to see what they get.
Yeah.
oh,
And I think VHB recommended that as well.
okay. And that's biannual
They use calcium, but it's really expensive.
reports. Okay. On stormwater management.
Yep.
Okay.
Okay, on a site improvement and management. Okay, so, I had no questions between 74 to 79. Though, okay. I think at one point there's a question here, applicant shall not use road salt or any paved surface of the property, which alternates such as sand or calcium magnesium acetate shall be used in lieu of traditional road salt. Do we need to, you made a comment about checking with Amy
Yeah,
Kowski on that?
yeah, she's,
Staff will follow up.
yeah, she's pretty strict about that stuff, so she should approve that first before we require it.
Okay. So you'll get an update on that to Amy, Christine, regarding,
Yes.
okay. And I can't, 78, no pesticides, or rodenticides not being used. Okay, so any other questions between 74, 79?
The only question I have on 78, which, I mean, is, not that I disagree with the intent of it, but with 242 tenants, that would have to be incorporated into the leases.
Definitely. Do you want to
Is
put
that
that
clear on
specifically?
here?
You can put it,
In order to be effective, otherwise it's just an aspirational statement, right? I mean,
Well, this directs the landlord can't.
the landlord can, but it doesn't say anything about, somebody spraying pesticide inside their unit or putting out a.
Well, actually, now that you bring that up, maybe it's part of the discussion here. The main issue here was the exterior,
Right.
all right, because that was a concern about animals in, nature. I don't have a concern personally regarding, I don't, the intent was not to make sure we protect the environment regarding the exterior.
Well, in that case, we need to be clear on the exterior.
Right. It wasn't, the intent wasn't to solve interior problems. It was leaving,
Currently reads, if I have ants in my
Right.
apartment, I can't spray.
yeah, I don't, I wasn't looking to restrict that. I was looking to restrict,
Yeah, permitted to be used does restrict that, though.
yeah,
I think that
it's
the-
an exterior, it's an exterior issue.
I think the
I
big
don't
thing,
think it is just an exterior issue. I thought the concern was that somebody tries to poison a rat, the rat goes outside, a bird eats the rat. You know,
Oh,
you have-
okay. I would, well,
Right. The good news
That-
is, I believe the applicant agreed to this.
Yes.
So I don't know that we need to belabor too far. The applicant said they were not going to use it.
yeah, I know, but the applicant, the idea was throwing these bricks in front of dumpsters and things like that. That was a concern.
But I don't know if the applicant agreed that they would put a restriction on the.
I don't think so. They didn't,
They
they,
agreed they wouldn't use them, but would they not allow, can you,
Right.
can you
This
take
is-
a can of insecticide and
this has-
spray ants in
yeah,
your
this
own
is-
unit?
yeah, I can't, this had to do with the applicant not, because the issue came up during the discussions at the meetings on maintaining the dumpsters particularly, and not using rodenticides in around dumpsters, et cetera. That was a main
I agree
concern.
with you, but I think it's just, I'm worried about a broad,
So remove or permitted to be used. That pulls in
I
the,
mean, people want to be able to spray for ants, I can't,
yeah.
for God, we're not going to restrict that.
Or whether we get more specific on, rat bait poison or something.
I don't know that far.
well, they also want to spray the pesticides on the bushes outside and, whatever, right? You don't want to do that either.
Or say exterior.
Or say exterior, okay.
I'd rather get it in the
But
word,
Amy's point is the rat could run outside, right? But it's,
I thought that was the concern.
Yeah, no, I guess my broad question is, does this apply to what people do inside their apartments?
right.
And how do you cover that?
I don't want it to.
So that's remove or permit to be used.
Personally, I don't want to.
Or permit to be used. If you remove that, is
Say
that,
on the property and in the common areas?
Or permitted to be used means landscapers.
Ah.
So what I was
excluding residents?
What I was going to add to address John's comment was this condition shall be directly incorporated into each lease agreement. But that's what you guys are contemplating right now, whether you want that language or not.
No.
No.
No, we do not. We do not. I don't. Brian doesn't.
Okay.
Can you say no external roadside or pesticide? And just add the word external,
Exterior and common areas?
exterior?
The common areas, they're
Could
gonna
be
wanna do it.
hallways and stuff
Yeah,
like
they're
that.
gonna wanna do it.
That's why I said no external.
Yeah, I mean, that covers
Well,
99%
they're gonna wanna
of
do it
whatever would be the
internal.
issue anyhow.
there's gonna be
They can do internal, that's what
Yeah.
we're saying. By saying no external use of roadside or pesticide.
No, they're sorry, I thought they wouldn't wanna do it internally, like in common areas.
Well, I think the concern was that, you know, the food chain. and then
Right,
The owl, and
Yeah.
you know, which is only gonna happen on the outside. Right?
unless the rat gets the poison inside and goes outside,
I hear what you're saying.
yeah.
I mean, the rat poison was the big discussion,
Yes.
public discussion.
That-
Thank you, Rachel, for doing this.
You're welcome. Yep, when I
And I get
rewatched
it.
it, that's what I
Again,
saw.
I'm just worried about it. This is a broad statement. How do you enforce it, right? And how do you know, and again, from a practicality standpoint, if you go to the extreme, are we saying no one can spray ant spray inside their apartment?
Which would be ridiculous.
This is not, well, okay.
Saying, right? So,
Brian, I suggested, was to say no external.
Personally, I don't
Add the
use
word external,
Just fucking it all.
in that sense, after the word no.
Yeah, I would put in, you know,
No exterior.
no,
exterior use of rodenticides or pesticides?
Whatever you guys want, so just like.
well, I know it's all about us, but I just want to make sure we get this right.
And again, I'm just,
Do we agree as a
Very
board
broad.
that this was intended to be
Okay.
external for the most part?
Okay, now, exterior. If you're sitting you're in your apartment, the exterior is the hallway.
No.
Okay, I just want to just form these little things out here. So we're talking about, you know, not to be used in the exterior landscaping, you know, on the, whatever. All right,
I
so,
mean, to Amy's concern, or not her concern, but the way he pointed out, is if someone puts in, say, rat bait or mouse bait inside their house, and it eats it, and it exits and dies outside.
but that's the, I
Again,
know, that's probably be more the exception than the rule.
Well, I just, from an enforceability standpoint, is my concern.
I understand what you're saying. Yeah,
Let's do, no rodenticides or pesticides shall be used or permitted to be used anywhere outside on the property.
that kind of sums it up. Question, folks, we're on page 19, just so you know if you're looking at your agreement. Okay. And it's item, so you know, it's also item 78, that's where we're on. Line item 78. All right, you got that squared away then?
Yeah, no,
Okay,
everybody else is
That works. Good.
okay.
On to number 80, parking.
Yeah, well, 79, okay, we're all set there, right? The applicant should provide amenities as shown in the approved plan set. Okay, rolling right along here. On to page 20, on to parking, circulation, and traffic. '80 to '83, I had no question, comments.
None.
Anybody?
No.
84, there shall be no idling. I want to put down no excessive idling. I'm not quite sure that's qualified, but at least it'll...
Define excessive.
Huh?
Define excessive.
And what's the intent of that sentence in the agreement?
On idling?
Yeah, what, I mean,
Yeah, well, you know, particularly on a construction site, I gotta tell you, it can be annoying, the fact that someone's got the truck running forever, and they don't need to be.
but it's also following construction. So it applies for 10 years from now when some resident goes out in a cold winter morning, starts a car and lets it run. You can't do that.
It's too restrictive.
The way it's written right now, you cannot.
Right.
That's correct.
That's why I think in adding the word excessive makes sense, because you think about school buses, they're not gonna shut them off and the kids are gonna get cold. You got an Uber or a Lyft driver that shows up, he's not gonna shut his car off while waiting for the person to come out.
That's why I'm wondering what I mean, the construction part I can understand. You don't want a truck sitting there all day long running.
I think adding the word excessive, certainly it's subjective, but it makes a lot of sense. Again, common sense is important, people. Anybody object to that? Can we just keep moving?
But is that a subjective term that's legally binding?
No.
Not legally binding? No, it's okay?
No, it's not binding at all.
Right.
Guidance. Or else just eliminate 84 completely if you don't want to make it reasonable.
Yeah, that's the reason I want to know why, is it in there? It's in there for a reason.
First of all, no idling means you show up, you're sitting in your car, you have to turn the car off.
I know what that means, but
Right.
why is it in an agreement?
So under 310 CMR 7, you are not allowed to idle for more than 5 minutes.
Well, can we put that in?
Sure. You want me to?
Sure.
Who enforces that?
Well, it depends.
Well, at least it gives people an
Has to
opportunity
be,
to,
meaning nobody enforces it.
right, but,
Good, it's based on something,
okay.
and it's reasonable.
So vehicles on the property site shall not idle for more than 5 minutes during or following construction, or just during construction?
During construction.
It's during construction of the project as approved herein. Okay.
All right, on 85 to 91, I had no comments. I mean, guys can go through, anything, anybody else pick anything up? Okay, and onward to 92. I just want to recommend a sentence edit, and it carries on to other things, but regarding the signs and landscape within intersections, site triangles, and site triangles are coming up here. I'm just suggesting we add in the beginning of that sentence, as required under Harwich zoning bylaw 325-17, signs and landscaping, et cetera.
I agree completely. You want to ask the question, who enforces that code?
Building commissioner does.
Actually, the process outlined for violations.
Okay.
A few of those that has it.
Amy, you agree with that?
Yep, I'll put
Okay.
it in.
Okay. 93. All right, so,
You know what, though, I'm sorry, Mr. Chairman.
Yeah.
We want to say, so we want to say as required under the Harwich zoning bylaw, section 17, or whatever that is. Signs and landscaping within the intersection site triangle shall be designed and maintained so as not to restrict lines of sight for vehicles exiting onto Queen Anne Road and Main Street. I need to protect ourselves if section 17 changes. That's why we don't usually reference specific sections of the zoning bylaw, because the zoning bylaw can be amended at town meeting.
Didn't say as amended, or as amended this time.
But as amended, it could get deleted, and then you don't have
Okay.
the protection.
so we get, do we
That
get, do,
still would make this correct, though, because if you quote it today and say or as amended in the future, if they delete it, then it goes away.
Right, and then they don't have to have, they can
Correct.
block sightlines.
Oh,
You don't want people
I
blocking.
see what you're
Is
saying.
it
Yeah.
Is it the MUCTD? Would it be better to refer to the municipal traffic code?
As currently defined as section,
Well, the other thing is
mean-
sections, the signage section has a lot of things in there.
It
about
does.
Political signs and business signs and,
Queen Anne signs.
yeah.
Well, this 325-17, as we will make reference to, is probably less important here than it is obviously on the discussion of Main Street intersection,
Yeah,
so.
but I think there
they-
is, the
why don't we just get rid of the number?
traffic signage is governed by the MUCTD,
I
I think.
think so, yeah.
There's a sign, because this thing talks, well, it talks about signs and landscaping, though.
Well, I think it's landscaping in regards to line of sight, though.
which is what 32517 addresses. Intersection, sightlines. What do you suggest, Abe?
I suggest not putting in the reference to the zoning bylaw, because if the zoning bylaw, if that section is deleted, this whole condition goes away.
Okay. Do you agree, Mr. Chairman?
No, no.
All right.
I'm only going to raise them up to find out what's happening.
But is there a way to reference like industry, current municipal and industry standards?
Do you need to?
I don't know if you need to, because you're just not allowed to restrict the lines of sight for vehicles.
Well, because I'm just thinking, again, a long time ago, the line of sight was, only like 50 feet, and then they made it 200 feet as vehicles became faster.
I think it lives on.
Mhm.
All right. 93, Mr. Chairman.
Okay. All right. This is reviewing the applicant's study of Queen Anne and Pleasant Lake Road. So, first of all, we mentioned here that the applicant shall fund improvements identified in the study, et cetera. All right. One, what is the timeline? Second would be the discussion here regarding the, what is the fair share cost calculation? And I recall, because this is an offer from the applicant, as far as things that they said they would do, they also specified a budget limit that they would be responsible for, and also a budget limit which they expect to, if other developments happen in the area, which we know there's one probably coming up right behind us here, that would possibly also have responsibilities regarding that intersection, or, okay, not responsibilities. They would have,
Impact on the intersection.
they would have, there would be stakeholders regarding that intersection. So they, it's not just the neighborhood as well as, the applicant, but there may be others that have a stake, become stakeholders in that intersection, so.
This is highlighted in yellow, because you guys have to make this decision, how you want to handle this. Do you want me to put the budget in here?
Well, they discussed what their
Yep.
budget would be, and I thought it was it 10,000 or was it 20?
I'd have to go back and look.
Did
I
somebody
thought it
say
was 20.
Do I hear 30?
I thought it was 20.
All right, so let's, wait a
But
minute.
I have to go back and
Let's-
look, I can't be certain. It
let's-
is it is on
okay.
that, Brian.
Yeah, I had this printed up, so in case it came up, so let's,
So I do think we need to put whatever the limits we basically agreed with them on.
yeah, it was in their presentation. So guys, if we go to this, go to the videotape here.
At the end, I think. That's mitigation.
Does not have amounts. I know they gave us amounts.
They did, I saw it when I was drafting the decision, and I decided not to, just to wait to see what you guys wanted to do. I probably should have noted it, but
I think it was 20 grand.
that's what I think too, but I'll confirm that.
Okay,
That
so,
number needs to be in there.
Under 90 on page 20.
Did I put it in? That might be why I'm thinking 20, but I do need to confirm where I got that number.
all right. On your final draft, would you put that number in? And,
Is there a timeline?
so here's regarding the timeline.
Well, they can't drive the timeline, the town does that.
However, but what they're also saying here is that it's a benefit not only to the community, but also to the folks, residents in this development, the fact that the town, which has done a major expensive study of the infrastructure needs of the area, which included Queen Anne Road, Pleasant 124 and Main Street particularly, that the town come up with a plan to solve what they already know is the current problem. And what they're saying here is that we're gonna get involved, and we'll help out with those efforts, but we want to not necessarily, have to wait forever. And if the town decides to do something, 15 years from now as opposed to 6 years from now. I mean, I think that's what they were implying during their presentations. And also, that they used the same reference in discussion of them helping out for a grant. They wanted to see it sooner than later, regarding grant writing, within a reasonable timeframe.
Yep.
So, I mean, is there a period of time that this board wants to feel the fact that they have to be, held accountable to still provide these efforts? Should we make it, phase 5? By the time that the phases are all done? I mean,
the town doesn't work that fast, right? I mean, right now, the capital plan for the town's probably out 5-8 years, right?
well,
So right now, it's not gonna
but,
happen.
that's a capital
Not
plan
gonna
for,
happen even beginning another 8 years.
not necessarily the fact that we're talking about if there's an opportunity, for infrastructure assistance on these roads, whether it's, rotaries or improving the intersections at 124, the town has the opportunity to prepare plans and request grants from the state to fund a major portion of the construction. So at what point does the town
What if we just said?
get involved?
Prior to project completion,
Prior to project completion?
it's 10 years. I mean,
Yeah,
Oh, that's reasonable.
no, they're still working on it, so,
Who knows when in those 10 years, but sometime prior to project completion.
I could live with that.
So on 93, because they're all different. So 90 is they have to do improvements identified in the road safety audit for Pleasant Lake Avenue and Queen Anne Road that the town deems necessary up to a maximum of 20,000. And then 94, they have to fund improvements to the depot at Old Chatham Road and Factory Road intersection based on a fair share cost calculation of up to 10,000 maximum. So we're discussing 93, where they have to prepare and submit to the board a study of the intersection of Queen Anne Road and Pleasant Lake Avenue to identify additional capacity improvements and associated cost estimates. Now, this is also a fair share calculation, so I don't know how we can require them to do it by a certain time if the other components of the fair share don't come in.
Well, I think,
Do you know what I'm saying?
but we don't know all the fair share people. We
I know.
got 29 acres that's being sold at the other side of the street, of the highway on 124. So it's,
well, I think that in this one here where there's a study to be done, you don't know what the study's gonna recommend.
But I thought that the study was to be funded by,
Right, which I think they agree.
or is it in the improvements?
I can't
That's what I'm-
believe the
that's what I'm
improvements could be
asking.
in the
That's
tens
why
of
I
millions,
highlighted it
right?
in yellow,
Yeah.
right? Yeah, I do think they agreed to fund part of the study, but
And not,
nobody knows what the study's gonna say.
or how much it's gonna cost.
Right.
And there's no way they're gonna spend 30% of $7 million if that's what.
no, it's referring to the, well, I don't think it refers to construction cost, it refers to the study cost, right?
Yeah, this is the study
The
cost.
study cost.
Well, but then applicant shall fund improvements identified in the study. That's what we're talking about. That would be
Yeah.
whatever's, so,
Right, I have no idea.
expand the intersection X, Y, and Z, $7 million.
But I do believe regardless of the fact they're fair share of that thing, I thought that that their offer was to not exceed a certain dollar amount.
I don't
which was-
know.
which was in
I mean, it
the-
would make sense. I can't imagine it be an
was in-
open-ended thing. but
Right, it was 20,000.
I don't remember. Yeah.
It was 20, I recall it 20.
I don't understand. Okay, yeah.
So the main question that I have is the road safety audit that's required under 90, is that the same as a study of the intersection of Queen Anne Road and Pleasant Lake Avenue? I
I-
didn't think it was, because they had it in two separate provision.
The other one was a study between Queen Anne and Main Street.
Right. So maybe that is it.
I mean, they do say fair share cost of design and construction on the Queen Anne Pleasant Lake Avenue intersection.
Doesn't 93 apply to their offer to help the applicant prepare the application for state grants? That's not in here anyway.
It's not, and I've added it as a condition.
Okay. Okay. The applicant shall fund improvements identified in the study based on fair share cost. That's where they agreed to the 10,000. It's, I guess, my question is, are we putting the prepare and submit to the board a study of the intersection of Queen Anne Road and Pleasant Lake Avenue? That's just gonna be on the applicant?
What they indicated during the meeting was the fact that they were going to pay X dollars, up to X dollars, of which it would be lowered based upon a fair share, contribution, by the other 40B at that intersection.
And adjusted by any grants that were received by
Right.
So,
other sources.
okay, so in this document right here, on page 12, this was their PowerPoint from the last meeting. It says POV 4 to undertake, and it says signal timing, road safety audit completed, and this is at Pleasant Lake Avenue and Queen Anne Road. So I think that we take out the first sentence of 93, because they've already done that. Applicant shall prepare and submit to the board a study of the intersection of Queen Anne Road and Pleasant Lake Avenue to identify additional capacity improvements and estimated associated cost estimates.
Stop there. We haven't seen it, so the applicant
Shall submit.
shall submit.
Okay. Okay, so then it says that to collaborate and participate, and we have, so 94, we have Depot, Old Chatham, and Factory. That's all set. They have up to a $10,000 maximum. And then,
And on slide 24, the only thing they have on that is fair share cost for design construction.
right,
Then the same thing is on what 93 refers to, fair share cost design construction, but there is no limit on that 93. So it seems like there should be a limit.
I think it's also 10, but I gotta go back and look.
Okay.
But I also think what's not in there is that first bullet point on the collaborate, is that they offered to prepare the grant applications for Mass Works and Housing Works.
Right, yeah, they did. And that's, if you, I bring that up,
Because I think that ties to the fair share, because the fair share would be whatever you not get from grants.
So, but on the Depot, Old Chatham Road, Factory Road, they also say fair share cost of design construction, but that's capped in 94. So I can't imagine the small one they would cap, the big one they would not.
I'll have to go back and look at the meeting.
And that could, to Ken's point, that could be
Yeah,
$7 million.
yeah, they weren't, they're in the $10,000 and $20,000 discussion, so
That
it's,
was a cap on at 20.
Yeah, it has to be 20.
So
It would
we
make
can't
sense.
leave in there applicant shall fund improvements unless we put the limit. Is that correct?
We have to, no, we have to say something. So we either say the limits up, capped at a fair share cost calculation of up to, or we have to say that, to be determined, based upon, that's my problem, I don't know what. What are we basing it on?
Where did you grab, on 94, where did you grab the 10,000 maximum? You had that in your
From
notes?
the video.
On the video, oh, okay. And there was nothing on 93?
I didn't, that's where I had problems, but I'll have to go back and look more carefully.
Okay, all right. Well, can we table that? There needs to be a maximum, I would think. I mean, I can't imagine this would be
can't-
something that would be approved, they would approve, agree to.
I don't know where table is right where I want to go unless we need to be scheduling another meeting, so table's not the right word.
Put 20,000 down,
20,000.
because we don't have the answer, right?
20,000 is my recollection of it.
No, there
No, there was nothing.
So let's make it 20, because that was the highest they offered. Yes?
I think it, first of all, we should have someone, applicant shall participate in fund improvements, not fund. I mean, I want to indicate the fact that they're doing or fund improvements, not to exceed $20,000.
Based on a fair care cost calculation, that's basically,
Up to, based on a fair share cost calculation.
Yeah.
Right.
or $20,000.
Well, no, they indicated in that they do up to 20,000, or they expect to do less based upon the fair share cost calculation being assigned to other projects in the area.
That's why you say to a maximum of,
So
not to
just,
exceed 20,000.
Yeah.
the way it's worded in 94, based on a fair share calculation up to a 10,000 maximum, make this a 20,000 maximum.
Yeah,
Same
okay,
wording.
that's fine with me.
Yep, me too.
Amy?
I do think participate is a good word. I'll put that in
Participate,
83, 94, and 90.
okay.
Well, no,
Yeah,
90
so,
is fine.
yeah,
But
participate in
93,
funding is fine.
93 and 94, okay.
Now, regarding that, if we go to my report, Ken and I's report, okay, so the infrastructure bond application by the town, I think it's, in additional, which is not in here, we need to add that we need to include in the decision the applicants agreeing to write the infrastructure bond application should the town of Harwich pursue state funding. Applicant indicated that this offer had to be exercised within a reasonable time frame. I suggest with time frame, we base upon the start of one of the phases. Start of or completion of a phase. So, phase 4 is up to like 8 years out, correct?
Yep.
So, I think if the town's gonna accomplish something on infrastructure improvement and go after state funding, maybe it happened, look at prior to the end of phase 4, or the beginning of phase 4.
Why not life of project?
Or
Yeah,
life of
I
project?
agree with the life of project. I think life of
Okay,
project.
life of project, okay, fine with that.
What's the life of the project? That they have to,
The completion of phase 5.
Final CO is issued.
that they have to, I'm sorry, I thought we were talking about the application for the infrastructure bond.
Yeah, so that's what I'm on. So, we want to put a time limit on the
Right.
fact that they're responsible.
So you're gonna give them to the end of the project? To do the
I'm giving
infrastructure
giving-
bond application?
Well, the town has to.
The town has to
Initiated.
initiate it. It's up to the town to do something.
They only agreed to write the grant, but
Mhm.
it has to be something the town's willing to do.
If the town wants to go after a bond, they're willing to write the grant, which is significant work. All right, so what we're saying here is that they're, they may decide to help out later, but I'm going to put them on the hook until the final certificate of occupancy is issued.
If the town can't decide in 10 years what they want to do,
Then they don't have to pay for it.
is it an open?
They don't have to pay for it.
commitment on their part?
Okay.
I don't want the town to go to them 15 years from now saying, okay, now we want you to write a bond. I want it done with the fact that it's going to impact to the benefit of this neighborhood and the residents in this.
But I also also
And this-
provide some impetus to the town to
Right.
address the issues which a lot of residents have brought up. Not gonna wait forever.
Yeah, I mean, I was thinking about phase 4, but I'm willing to go to phase 5.
Or to be filed within 10 years from the date of this decision.
It's the same to me.
I think it's more finite if we say.
Okay,
10
that's
years.
great, I'm good with that. Anybody else comments on?
I didn't hear what.
Amy's suggesting that we go with, that they're on the hook to write this bond, grant, excuse me, to write the grant if it's done within 10 years of of this completion of this decision. They're asked to do it by the town. It's,
So better than the end of certificate of occupancy of phase 5 is 10 years from now.
Schedule slips or
In
something.
theory, it's the same. I mean, in planning, it's the same.
As of today, it's the same.
Right. All right, 10 years, that sounds good.
Is that a new condition? That's not one of these numbers, is it?
yeah, it's right here.
What number?
It's right after, it's right before 94. Oh, no, it's not in here.
That's my question.
It was never in there. And I just found, it was a condition that I felt we need to put in the draft.
Grant application, not bond application.
Yeah, it's a grant, you're right.
Amy, are you clear on that?
Yep. Applicant shall prepare an infrastructure bond grant application to be filed within 10 years of the date of this decision.
I don't think the word bond is in there, it's just infrastructure grant.
Infrastructure grant application.
Whatever.
Well,
Wait a minute. We gotta put in the fact that they have to do it based upon the request of the town.
Okay.
So, but the town has to request this within 10 years.
Yeah,
it says right here, Brian, should the town
It should be, yeah, if requested
choose
by
to
the town.
pursue state funding?
I realize that, but she wasn't,
Oh, she hasn't got
Amy
it.
wasn't doing this word, wasn't doing mine word to word.
Okay.
So, you know, my verbiage is on item E under 93. However you want to word it, Amy, is certainly preferred.
So should the town choose to pursue this within the next 10 years?
Should the town pursue this in the next, within 10 years, should the town pursue this within 10 years of this decision, the date of this decision, the applicant has agreed to
Assist in the grant.
assist in the grant writing.
I think not should the town, should we just say upon request from the town?
Okay, that's fine.
Yep.
Okay.
You want that? That would kill you.
Applicant shall
Put it in the hospital.
prepare an infrastructure grant application.
There's a lot of sodium in this.
Probably, I would suggest that
Um,
they'll be
But
assisting in
so,
the
yeah, that's what
preparation of
makes
the
it
grant,
taste
because I
better.
don't think the applicant can submit the grant, it has to be submitted by the town.
Oh, yeah.
I said that the applicant shall prepare an infrastructure grant
I
application.
think they should assist in
No,
preparing.
no, but, well,
They
it's
said they would do
prepared,
the whole
it's prepared.
thing.
They said they do the whole thing.
Right, yeah. Who's gonna submit it?
The town
We're
does,
just
but they're
saying-
gonna, they're gonna prepare it.
Okay,
Prepare for the town submission.
okay, fair.
All right, upon request from the town, within 10 years of this decision, date of this decision, the applicant shall prepare an infrastructure grant application.
The first assessment.
And this is specifically as it relates to Queen Anne and Pleasant Lake?
That's what I'm trying to figure out, okay.
Ryan, yes?
No, I think, not necessarily. It refers to,
Yeah, because they also mentioned potentially sidewalks or other things.
but, yeah, they don't,
Main Street.
70.
doesn't,
Say
I don't,
application, grant application.
I'm not suggesting sidewalks, but I think it has to do with the infrastructure of Queen Anne, Main Street, and Pleasant Lake Avenue.
Okay, that gets it.
I think we throw those three roads in, I think that covers it, right?
Yep.
So what are the three roads again, I'm sorry?
Queen Anne Road, Pleasant Lake Avenue, was it, that's correct, and Main Street.
Okay.
you know, almost like the infrastructure triangle. Okay, 94. Okay, I hear it. Was there a timeline discussed on that either? I don't recall. So they just can't go out and fund improvements. They have to, someone's got to request them what they want to do. So it's applicant shall, at the request of Town of Harwich, do we, I mean,
Same 10 years on it, just to be consistent?
I would,
yeah,
They've been 10 years?
at the request of Town of Harwich.
Yeah.
within 10 years of the date of this decision,
Right.
Just to keep
all
it
right?
consistent.
Yep.
So,
No,
on 94, they said that they would, prior to the issuance of a building permit for the first residential building, that they would assist the town to prepare.
okay, they
the
put a timeline
grant.
themselves, all right, that's what they offered?
But then, the contribution has no, timeline that I saw. But I can add that to 94. Add, prior to the issuance of a building.
I know it means an expert, but I gathered from the conversation that these grant applications can only be submitted like once a year.
Yeah, it's actually, it has to be in, it has to be in like in June, or whatever of that year, or, you know, miss it, you're,
Or the following year, but you're gone for a year.
it's basically, the bottom line, if you don't get in by the beginning of the year, because they, between the process and so forth, the funds are allocated, if I recall reading about it, in June, and then the disbursement starts in July of a given year.
Based on that is why I don't think we should tie it to
Why don't we just-
phase or a
Right.
permit application.
I
Why don't we
agree.
just have them put in the $10,000 into a account before the final certificate of occupancy? That's the easiest thing to do.
Okay,
Yeah,
all right, that works.
to be refunded in the event that the town doesn't do anything. There's got to be an expiration on their escrow account.
But they're contributing 10,000. So,
What if the town doesn't do anything?
well, I don't know if you want to, tie the town's hands. I mean, I guess,
Kind of what I do want to do as far as make the town have urgency to get something done.
okay,
Yeah.
that's up to you guys. It could be returned then.
Well, otherwise, they're giving you 10 grand for something that never gets done?
It's gonna get done eventually.
Well, I don't know. No, I'm not quite sure about that, all right? So it's, I just as soon put a, you know,
I think we should stay consistent to John's point with the 10 years. If it's not
Yeah.
spent in 10 years, they do get it back. That's, again,
Okay.
there. And I would hope, my disappointment is with the town of Harwich.
Okay.
I mean, we're not telling the town they have to do these things, but if they're going to get the benefit of these, of the applicant's money, they ought to, you know, they should be doing something.
So at Queen Anne and Main Street, they agreed to do the grant before they also agreed to do the grant application before the first building permit.
Then again, should be
Right.
funded into that escrow.
Okay,
Yeah.
fine. Okay. And the same with Pleasant Lake and Queen Anne Road.
Yep.
So I'll change all three to reflect what we just discussed.
Excellent.
Okay. Okay.
All right, we ready to move forward? Okay, I have no questions on 95, or comments. 96, consistent with the traffic transportation impact assessment. Okay. All right, so item C. I think that already got addressed. I think it should be deleted because they've changed the site plan. You know, one, everything got moved up as far as the childcare center, but they've already adjusted the site plan to widen the site, you know, the sidewalks and so forth to make room for the buses.
I agree.
That was already done. So I think C can go.
Okay.
Absolutely.
All right. And on pedestrian accommodations, on F, I would either delete item F or remove the reference to Main Street in consideration of a possibility of having a condition for a second paved road to Main Street. Because I would get rid of Main Street on that, because if they do a road, it's not gonna have a side, it's gonna be the 18-foot road, which people can walk on and ride their bikes on. There won't be a separate sidewalk. So I would eliminate extend to Queen Anne Road and eliminate Main Street.
I would agree.
But they are required to do the emergency access.
They're required to do that,
Okay.
right? So the road's gonna be there for walking anyways. There's gonna be emergency access road, it's gonna be gravel, but it's walkable.
Okay.
Do we need F at all?
Yeah, I don't know if we do.
I mean, the
I
site,
don't even question we need F at all. It's good, well, it's a good,
That was my first question.
that
I
was,
would
that
just
was
strike
probably
it.
where I should have started.
yeah. I mean, the site has walkways.
Walkways, all right, so let's get rid of F. Any other comments on that? Okay. Okay. I had no comments myself from 97 to 101. Did anybody else have anything to say about those items? Okay. Onward to signs. That's what I need. I need someone to give me a sign. All right, so I have no questions on 102 to 106, no comments myself.
None.
None. Landscaping.
The only question I have is just the wording of 106 is they can't install signs on a public road. They shall
Shall-
fund it.
Yeah, she'll pay for the installation, fund the installation, yeah.
Okay.
Fund the installation.
You know, interesting little note here, but the speed signs on the roads, like on Queen Anne Road, et cetera,
Poor, very poor speed signs.
you know, that's the state. The town can't adjust those.
Right.
I didn't,
The white sign is
Go-
covered by the state.
yeah, it's white signs governed by state. It has nothing to do, I talked to them, I talked to the police department about all the signs and so forth.
And the yellow sign is non-enforceable, is that correct?
Right.
It's for guidance?
It's
not-
guidance.
It's not not an enforceable speed limit.
Right,
I didn't know that.
yeah. Because we asked about adjusting the, you know, speeds on the road, and they said, right.
Yeah. I had no idea.
My note.
And Ken found out in one section,
The police department.
one way, in the same section of road, one way's going 40 miles an hour, and the other way, the speed limit was 30?
Yeah. That's
On the
about
same section of road.
It's about 100 feet.
100 yards.
No,
Yeah.
100 feet.
100
Drove it
feet.
yesterday, and after we talked. And your brakes work?
I drove by it, yeah.
You know, so one way you can go 40, the other way you only go 30.
And that's at the entrance.
Just makes no sense to me.
Permanent radar speed feedback.
Where are we?
Speed.
107
Okay,
landscaping.
so I'll put that in.
All right, landscaping.
Those two signs are also limited to 10,000.
Yep.
All right, 108. I'm not quite sure why that's needed. Or maybe it's just fine, I'm not quite sure. That was a question you had, Kim.
It is. I think it must be boilerplate, because they're building this in a timber.
But there are some trees that are designated in
Okay, all right, so it stays in,
the site plan.
all right,
Correct.
yep, yeah, he's right, he's right.
Stays. Easy.
I, my edit for, I back off my edit on 109. Okay, we don't need it. I think First of all,
I guess I would ask Amy's guidance on this, because that statute 32517 that we keep making reference to, Amy, it specifically says how intersections and vegetation and sight lines have to be maintained, and fences and anything else. So is 109 generic enough, or do we have to, and I know you said, what if 32517 changes?
Right. This is a standard condition that we put in every single one, so,
okay, all right,
yeah. I
leave it
don't-
alone.
All right.
All right, we're now going on to conservation. I no comments on 111 to 112. And on 113,
Just gonna delete the first word.
can we delete all?
Sure.
Uh,
Just a little further to clarify that, isn't the town has a role in identifying which ones they want removed, right? The conservation commission.
Conservation, yeah, the conservation agent.
Yeah, this is something that they proposed, the
So-
developer.
Can we clarify that as identified by,
Well, there's a list of invasive species.
but there's spots where they don't want to disturb. I think there was.
Yeah, you're right.
You know, even if there is an invasive species, right? So I think it was there was one section
Okay.
in particular where the knotweed is growing, that they wanted to dig it out, but I don't think they were gonna go through the whole property and remove.
As identified by the Conservation Department.
So was that invasive species as identified by the Conservation Department?
In wetland C shall be removed.
Okay,
Yeah.
that's fine.
I think it was one specific invasive species there.
Got it.
All right, on 114, I learned in talking to Amy in Conservation that not all organic fertilizers are low in nitrogen. So even though it's natural, she said that some of the natural organic fertilizers have more nitrogen than the stuff that Scott sells, okay? All right, so she suggested, and I agree, that we put in the term low nitrogen
After the word natural.
after the word natural.
What's the definition of below?
I have no idea, but there's a, like, anything, what's fat-free, I mean, I'm not quite sure, but it's,
It's Amy, I guess. Is low a good term? Legally?
Lower, slow release.
Is that
Low
another
or slow
undefined?
release, how about that?
Lower slow release, there you go.
So all right, so also we need to put in the use of fertilizers after initial plantings, because they discussed that. So the use of fertilizers after initial planting shall be limited to the use of natural, low or slow-release nitrogen organic fertilizers.
Okay.
115 is regarding wetlands.
No, 115 is endangered species.
Oh, I'm sorry, you're right. What the hell did I miss? I misnumbered this, didn't I?
You've got no changes on 115.
No changes, huh?
I'm on conservation, I'm looking at my report. Okay, you're right, okay, I just,
115, no change.
I think this would be a new
Yeah,
116. The thing that you're talking about is something that they agreed to, Brian.
Which one?
That they agreed to reflag the wetlands.
Yeah.
Just confirm.
what number was that now?
We'll have to add a new condition.
Okay, that's right, okay.
Yes.
It's a new.
Well, that's an added
That'll
condition.
be 116.
Yep.
When do you want them to do that, to reflag the wetlands? I mean, I didn't put anything in about that because that's not really under our jurisdiction. If they're gonna reflag the wetlands pursuant to the Wetland Protection Act, they have to go to conservation for that. So,
That's beyond our scope, so.
yeah,
And they agreed to it, like they're.
They agreed to reflag it, because the current flagging is getting old, and some plots of it might be missing.
Can we say prior to the issuance of the building permit? Or,
It's late.
of the-
Prior to the beginning of construction.
Well, they gotta, before they start doing, before they do any type of land clearing and whatever, construction, that's when they need to do it.
my point is you have no jurisdiction over the wetland line because it's under the Massachusetts Wetland Protection Act.
I know I'm not on the wetland line, but don't I have jurisdiction that they have to do it?
No.
You already agreed to waive the wetland protection bylaw.
But they agreed to remark. How do we include a condition that they're amenable to?
And were they, but before we do this, I couldn't figure out whether they are going to reflag the entire property or only portions of the property.
It was the wetland portion.
All of the whole property.
Well, it'd be, I think anything intersects with the planned construction area.
Say within limits. of the-
So,
I mean, there were wetlands that are nowhere near the construction area, right?
No.
it wasn't clear
so.
on the tape that I saw. It wasn't clear where they were gonna do it. I guess we could do,
How about we put down in the decision that the applicant has agreed to coordinate with the Conservation Department, the reflagging of the wetlands?
okay, as agreed upon by the applicant shall,
Coordinate with the Conservation Department, Harwich Conservation Department, the reflagging of the wetlands in its timing and timetable. Excuse me.
so, but you want them to meet with conservation, do you want them to meet with conservation prior to the issuance of the first building permit?
Yeah, and then still up to the discussion with the agent when they do.
All right, as agreed upon by the applicant shall coordinate with the Conservation Department to reflag the wetlands within the limit of work?
That's fine.
Okay.
If that's fine with everybody else?
Yep. Yep. You had other conditions to add? You had two more, Brian. You talked about that. and
Yeah,
that.
yeah, you got that,
We're still in conservation.
right. Okay, so, I don't know why mine's different than yours now. Okay, so additional conditions here. And they also, during the meetings on the 14th or the 15th, the applicant agreed to this, well, didn't object, let's put it that way, excuse me. When the conservation agent and requested the applicant should file a ANRAD, A-N-R-A-D application with the Harwich Conservation Commission and Mass DEP to confirm protectable wetland classifications and boundaries.
So that's what we just,
That's what we just did.
that was what we
Okay,
just did.
all right, so, okay.
But I'll add,
Is that it, but that's an ANRAD,
yeah, an area of resource,
that's what we need, well, okay, so they're gonna be doing that. All right,
that's an abbreviated notice of resource area determination,
right,
delineation.
okay, all right, thank you. Minimize intrusion into the 100-foot buffer. If we go to the,
That's what 112 says.
does 112 say that?
Yes.
All right, so we're all set there, okay. And they also brought up the fact that they would, regarding endangered species, the applicant should complete the IPAC determination keys and coordinate with the USFWS if necessary.
That's 150.
It's 150.
Is that 115? All right, so I guess, all right, we're all set, okay, thank you.
Yep.
All right, they're all in there. Okay, next up, accessibility. I had no comments on those. And on general and anybody have any, we're all set with that? General conditions.
So,
The,
I'm sorry, Mr. Chairman,
yeah,
other conditions, I don't, where were you headed now? You weren't gonna go to the voting thing yet, were you?
no, the last page here, on page 22, I'm sorry, not page 22. The next, okay, so accessibility, then all of a sudden, she's got, Amy had put down here, the last item was general conditions. Okay. So, and then after that was number 118. Her paragraph there, which I didn't have any issues, any comments on.
I agree.
Okay, all right. Now, there was also discussion on a condition to add, to consider adding, a project notification form shall be filed with the Mass Historical Commission, MHC, to determine any archaeological sensitive areas on the project site. Though I thought I had read that someplace else in this document, but I don't think I think I might have missed it.
Christine, did you say?
I think it may have been in the beginning, I think.
Yeah, it's there somewhere.
Yeah,
Is it already in there?
I think so.
Well, it needs to be.
I didn't pick up on it, and so I just threw that back in.
Um, 34. So it's 34H, it's on page
Oh, it's there, okay.
12, and it says that prior to the pre-construction meeting, no site activity shall occur, no building permit shall issue until the applicant shall have, and then H is submitted to the Massachusetts Historical Commission.
Okay, good, okay, I didn't see it, all right,
Application form.
all right. Yeah, why don't we,
One condition
yes,
after the big one here.
you want to do, break now, or going to the next one? That may take a little longer. All right, we're going to grab another break till 12:30, okay? All right, thank you. Anybody bring a box of candy bars with me?
Yes.
You did, for the one across the street? We should be. Yeah,
true.
is it emailed me? Is it the one across the street? Is it, who's the attorney? Do we have anybody yet?
Stable?
No, the developer, I don't know who their attorney is, their developer
You
emailed me.
were not ET?
Hung around.
I haven't heard back. Why are you going all the way there?
Stone side, but down that way is off into the.
No, I just stand.
whenever I work, I get lunch there.
That's why I don't wanna go there. No benefit there. Maybe Cape Tech.
Oh, very good.
Yeah, it is. A great program.
Okay. We're back. Just going back over my notes, not to labor back on it, but on the fertilizer, so I know we talked about natural and low nitrogen. I think phosphates ought to be thrown in there as well, low nitrogen, low phosphates.
Phosphorus?
Is it phosphorus or phosphates?
It's phosphorus.
Is it phosphorus?
Yeah,
All right, so it's,
that includes phosphates.
I see.
You can't do that?
No, you can't take,
Can't what?
Can't take input, that's fine.
Oh. All right, so anyways,
We're not sure that. No fertilizers containing phosphorus shall be applied.
okay, good, we're in there. All right. Okay, so we're down to,
118.
all right, second connector road, next thing, general condition is, second connector road condition, Pine Oaks Village 4. All right, so this came up at the last meeting. I took the statement that was offered, suggestion by the applicant, and I revised it. Obviously, the revision here, in a way, eliminates it being an option. So, just so I read it so we all can, at the same time, absorb it. Proposed plan includes an emergency access road from the project locus to Main Street. This access road is initially permitted to be an emergency access road. Prior to the completion of Phase 5, the road will be constructed as a full secondary access road for Pine Oaks Village 4, subject to the following requirements. The paved width shall be 18 feet. The road shall be constructed according to the same specifications as for the project roads approved by this decision, except as to paved width. When the road becomes a full secondary access road, then the applicant shall notify the board in writing of its such election, such completion, shouldn't be the word election, such completion, of completion. And within 60 days thereof, the town shall be responsible for and pay for removal of any vegetative or physical obstructions collectively, the obstructions, within the public right-of-way that interfere with the site triangles prepared by the applicant's traffic engineer. No. We gotta eliminate public right-of-way.
No, you do. That's correct.
I think you need to eliminate.
You gotta keep reading it.
Okay, so public right-of-way, if you, also with the site triangles prepared by the applicant's traffic engineer, Van Ness and Associates, Inc., and likewise, whether pursuant to zoning bylaws 325-17 or otherwise, cause any obstructions within said triangles on private property to be removed either at the town's expense or the expense of the private property owner, included any required survey by the Harwich Town Engineer, permits or approvals that may be necessary to remove the obstructions.
so you're saying the town's gonna go on private property and remove this? They can't.
The town can require, if it's, the rule is, the zoning code is that, an obstruction that's 3 feet
15
height
feet.
or more, about 3 feet from road grade, has to be removed, okay? So it is obviously up to the landowner to do it. The question here is the fact that, so I suppose we have to eliminate the fact that the town takes it off. but then it would require a landowner to be in line with the bylaw.
So you have, within said triangles on private property to be removed either at the town's expense or the expense of the private property owner.
Should
The
be-
town can't pay for.
So we get rid of the town's expense.
Can you pull up 32517? Let's make sure we've got the right verbiage there.
I got it with me.
Well, you're just reiterating, I mean, that is what is currently required of any property owner.
That's right, the whole town, and they do this all the time, where the highway department goes down and tells folks that, sorry, you gotta remove this, and they typically do it. Occasionally, the town has had to find other enforcement. It's in our code here, but here, here's the...
You want me to read it?
Sure.
32517, fences, walls, or other enclosures. A fence, hedge, wall, or other enclosure may be maintained on any premises. In order to preserve and promote the safety of the public, any fence, hedge, or shrub, or other growth or enclosure wall on the corner lot or curb obstructing the view of motorists and situated within 15 feet of a public street or curb or sideline thereof shall not be permitted by the owner or occupant of the premises to exceed the height of 3 feet above the road grade. Any and all trees within said 15-foot area, in parentheses, shade trees to be subject to provisions MGL 87 sub 3, shall have limbs trimmed to the height of 6 feet above the road grade, provided that on a corner lot, no structure or vegetation shall be over 3 feet in height within the site triangle as hereafter defined. The site triangle is defined as an area within a triangle formed by two lines measured along the center of the nearest lane of the traveled way of intersecting streets from the point of intersection for a distance of 25 feet, and a third line connecting the points on two legs. The height restriction shall designate the distance above each point in the plane of the site triangle. End quote. So it does not say who pays for it.
The town can't pay for.
No, right,
work on
I
private
realize
property.
that, right, okay.
The anti-aid is, the anti-aid amendment, we can't do it.
Could the applicant pay for it?
I think
No,
The applicant can't, no, the applicant, we
there's
can,
no way we could.
no, the
require-
applicant cannot be required, the applicant could,
Can't go on private property either.
But they
could obviously help out if they wanted to.
Reimburse.
Huh?
They can reimburse, right?
Yeah, we can't force them to reimburse them.
It is on the owner.
So why not done?
We can't do that. It's on private property.
it's on the owner of the property.
The code, I mean, this code gets used,
Just
Hedges and shrubs.
yeah, in talking to highway department, they, you know, this happens on a regular basis where people have said, you know, you gotta lower this, lower that, and have to conform because of sightlines. So it's not, it hasn't been done in the past. It's not unusual. We never dealt with it in the past because we deal with, typically, we deal with lot lines in.
I recommend and propose just two adjustments.
Sure.
In the second sentence, it says the access road is initially permitted. There's no permits, it's proposed to be an emergency access road.
there's not a permit. He's
permits
he's
issued
way up
for
here.
anything.
Oh, okay,
It's not permanent.
So it should be proposed.
Proposed.
yeah.
And then, given the fact that we're requiring this before the end of phase 5, I think you just should say applicant's traffic engineer, not who it is, because that might change
Okay.
Right, okay.
8 years from now.
And I'm going to make a suggestion, Mr. Chairman, that the period be placed at the end of the word removed and nothing to follow. In other words,
Where is that? I'm
likewise,
sorry.
whether pursuant to zoning bylaw 32517 or otherwise, cause any obstruction within said site triangles on private property to be removed, period. When you get into either at somebody's expense, your expense, whatever, that's irrelevant according to the statute.
And then what about,
We need to have this, to bring in the town, so
No, you don't.
No, first of all, a private surveyor cannot go on public property, private
They
property.
can- There's a statute that allows surveyors to go on private property.
Even a private one? Okay, there is. Oh, I thought they couldn't. They can. Okay,
A licensed surveyor.
okay. All right, so how are we finishing this up? Are we going to period after we move and that's it,
That's it?
Amy?
25-17
That's
already.
Up to you guys.
Okay. All right, discussion, gentlemen?
So this is currently emergency access road, that's what they're proposing at this point. Would any of this be required as far as removing the sightlines on an emergency access road? Is this only if it becomes a permanent street?
That's a great question. That's up to the town to enforce it.
Well, is that, under 325-17, if this is a street, this is the bylaw, does that emergency access road qualify as a street? It's a dirt gravel road that's emergency access to street. In other words, does this have to be done anyhow?
I think-
Regardless of whether it's paved or anything?
I think it's in term right now that the town probably views the emergency access road, which is seldom used, as little more than a driveway. You know, as far as that kind of access. I mean, this law applies to intersections of streets. It doesn't, you know, but actually that road there now, it is an ancient road. It's an access way, so it is a road. So the town may decide, it's up to the town whether or not they want to implement.
Well, Police and fire have access through that road, and
Right.
they can exit from it.
Right.
It does say measured along the center line of the nearest lane of the traveled way. So I don't know if an emergency access would have to comply with 325-17.
I don't think it technically does.
But you are requiring it, so that's fine.
Well, wait a minute, there's a discussion I brought up here, but we don't have a consensus of the board.
I guess the question is, it's not certain that it would be required no matter what.
If
Under
it's a road,
325-17.
if it's something other than emergency access, if it is an ingress egress road, it is required under 325.
Correct.
Correct. But if
Yeah.
it was just left as emergency access, would it
Right.
also be required? So we're not
No,
asking,
I don't think so.
it would not be.
I don't think you can consider emergency access a traveled way.
I would agree.
Okay.
Correct.
So the sight lines, removing vegetation, removing other things, we're forcing that by enforcing this will be a road.
The board's not enforcing it, the
Well, yeah, I know,
town.
but by making it a road, we're bringing in that statute.
Right, and it's up to the town, it's up to the town to make the decision on enforcing that statute. It's a bylaw, like any bylaw in town. It has to be enforced, if the need is there.
And you are requiring that become a road by Phase 5.
Yes,
That's
in my recommendation here, right.
Yep.
One, we'll have safety issues regarding, at the end of that street there, it's less than 3/10 of a mile to get to the bike path in that area. Reduces traffic on Queen Anne Road as well. Reduces traffic to that intersection of Main Street and Queen Anne Road. There's just, there are a lot of pluses, but particularly for, I think, the enjoyment of the people in this development, as far as to walk there, to go places, there's a lot of opportunities there.
I have no issue.
John?
Good.
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 Dave?
The safety thing's probably the compelling one, right?
That safety is huge. That's the,
You know, whether it's safety for vehicles, getting traffic off Queen Anne, directly on the main, that intersection of Main and Queen Anne, and
walkers, people on
very, very
bicycles.
close, that's probably as important.
Yeah, it's 3/10 of a mile from the bike path. I just think it's It has a lot of pluses for the enjoyment of the residents and safety, their
Comment
safety.
down here, bro.
Yes.
If I could ask a
You
question.
can-
Amy, if this,
Can you speak
is
up for everybody?
sorry. If the board chooses to place this as a condition within the decision, is there a concern that this sort of condition could get overturned from HAC because they may view this as making the project uneconomic?
It's always a concern.
Yeah.
There's always the concern that it would make it uneconomic. I'm not really sure what that would entail. I mean, I think we're requiring that they pave, but we're not requiring that it be any wider. Correct? We're leaving it at
Correct,
18.
even
18.
narrower than the other streets.
Right, but we're leaving it at, the emergency access is already proposed to be 18.
Yeah, that's right, yeah.
Yeah, so I think they would be hard pressed. However, HAC will agree with them no matter what, but.
Thank you.
Okay.
In the housing, HAC, should I get the numbers, letters right? They can pick things out and say, this doesn't work, and eliminate them?
Well, the applicant will appeal.
Yeah,
And if the applicant is
exactly.
going to appeal on the premise that, that the conditions make the project uneconomic, they have to identify the conditions.
Right.
The applicant can also appeal that the conditions are not in compliance with HAC decisions and case law, things like that.
Right.
But usually they're appealed condition by condition.
So one condition that pulls out, but everything else remains intact. Okay.
Hopefully,
Yeah, but normal, typically,
typically, yeah.
yeah.
Yeah, an appeal of one condition doesn't impact,
If they're going to appeal this condition, they're going to appeal all of the conditions that require that they provide money, even though they've agreed to them. Because they're filing an appeal no matter what, so.
okay, all right.
I mean, the only thing we changed was, from what they proposed during discussion, was at their sole discretion. So,
Right.
but I guess financials would sway their hand.
Yeah,
one way
I
or the
mean,
other.
and again, we're not telling them to install a road that they're not that they're not proposing. We're just telling them to pave it and make it accessible.
Right.
I don't think it's significant, but, again,
Okay.
they did want it at their sole discretion.
Okay. Amy, next up.
You're going to vote on, you're going to vote on the waivers other than, I have to pull it out, sorry.
Chapter 310, Section 14, performance bond waiver not granted.
Yep. So I would do a vote on the waivers, that they're all that they're all approved other than that one.
I'm sorry, I need a,
So that would be a motion to approve the waiver list submitted by somebody can just say so moved, okay?
right,
A motion to approve the waiver request submitted by the applicant on October 7th, 2025, except for the requested waiver from Chapter 295, the Code of Town of Harwich, Section 14, Performance Bond.
all right, it's a motion by John. Do I have a second?
Second?
Chris? I mean, Al? Discussion.
Just point of order, when do you have to anoint voters?
You have five regular members, you have to use those.
They're appointed.
Okay, just to make sure we did it.
Well, just clarify it, you asked a question, voting in this case would be Al, Donahue, myself, Brian Sullivan, Brian Sullivan, Chris Murphy, John August, and Ken Dixon. Okay. So we have a second on the waivers by Al. No further discussion? All those in favor?
Aye.
Aye. Okay. Now, we're going to have, we have an amended, obviously, decision.
So you're going to make a motion to approve the draft decision as amended, as discussed, and allow the chairman to sign the decision.
So moved.
Okay, Chris?
Second.
Motion by Krish. Al seconded. Any further discussion? Yes, we can.
Mr. Chairman, I would just like to go on record, before I take my vote, that I think that the public's input into this project over the last 6 months has made it a better project. It is not a perfect project. I agree with some earlier comments, specifically about the location, this lack of amenities. I don't disagree. It's impossible to disagree because physically they aren't there. Traffic, in my opinion, is the biggest issue because it's a safety issue as well. And the fact that we're pinning all this bad traffic issues on POV4 really isn't fair. We know, and I think we've mentioned this before in open hearings, that the town of Harwich spent almost $250,000 on a traffic study about all the bad intersections that we have, and they haven't done anything about it. It's still in a drawer someplace. Yet, here we are now, knowing that this project is obviously going to add traffic, as will future 40Bs that we're all aware of probably going to come up here. I just hope that you will spend, you the public, will spend as much time lobbying the selectmen to fix our roads and our safety issue as you have spent prudently here influencing our decision and the project that we've got in front of us. Because if that's not the constituents, I don't know if it's ever going to get done. And that's a hazard to all of us. It's really important. And I will say that the need for for affordable housing, specifically our towns, forget the state, our own town's need for more housing overrides my concern for traffic, and I am certainly going to support this project. Thank you.
Thank you. Any further discussion? Okay. All those in favor of approving the decision to be amended, all say aye, please.
And allowing the chair to
And
sign.
allowing the chair, myself, to sign when it's completed. Before I call for the vote, when do you anticipate that timeframe in that to be?
Oh, we have 14 days to file it with the town clerk.
Okay, all right. All those in favor?
Aye.
It's unanimous. Thank you very much, folks. And thank you, everyone, for everyone's time and efforts regarding this project and the review of this. It's been an interesting experience. Thank you.
Motion to adjourn.
All right, have a motion to adjourn, please?
Second.
Oh, wait a minute, excuse me, no, I'm done with the agenda here. Is there any new business to discuss?
December 1st.
Any old business? Okay. And of course, we're adjourning, our next meeting is December 10th.
I'm away the next week, so I'll get it done.
This meeting is adjourned, thank you.
I do
All those in
feel bad.
favor?
Aye.
Aye.
Money, I still can't get my